Why business deal? He's sweet. See you. Happy Sunday, everybody. I realize how important this session is and how important the work will be as the week unfolds during this conference. So in spite of the fact it was Sunday, I managed to threaten myself down here. So, but I am happy to see you all. For me, when I look back, I always go back to Tawasin in my heart. It was June the 10th, 2003, when we gathered in Tawasin in regard to the same issue of children and families. And at that time, there was a lot of sudden tragic deaths of babies, children, and we realized that, you know, we had a responsibility to do something about that, about those tragedies. And the political climate back in 2003 was pretty volatile. It was pretty polarized between our three organizations. And it was the first time that we'd ever gotten together in the same room to discuss this important issue. And it was an amazing transformational meeting. What happened in Tawasin after a couple days of intense discussion, we put together a declaration, a document, which became known as the Tawasin Accord. And if you read the Tawasin Accord, it's relevant today. And it, in many ways, served as a guiding light for us. So that's 21 years or thereabouts. And I would just like to acknowledge the leaders that are no longer with us, that were very, very passionate in coming to these meetings and expressing their frustration, their anger, their heartbreak. And, you know, I know they're still here. They're here in spirit, and, you know, they're urging us forward. I'd like to acknowledge Ray Harris in the back there. Ray's been here forever. And he's our, in many ways, he's our resident elder at the First Nations Leadership Council. And he doesn't speak often, but when he does speak, there's a lot of weight to what he says, and he's very, very passionate about children. So I'm glad that Ray's here. I always call her Chief Judy Wilson at the back. Judy's been part of this fight for as long as I can remember. So I want to thank all the veterans in the room, Chief Roger Williams. So good to see you. I missed that cowboy hat. So it's good to see you back. And everybody else that's here. About 2 weeks ago, I had my first great grandson. So Jonah and I have 15 grandchildren and 1 great grandson. And I'm telling you, I remember Ray talking about him having great grandchildren. And it's an amazing feeling when you look down and you see that little baby. And you know in your heart, if you look out, you know, the perils, the challenges that await, and the work that we have to do to change that narrative. We're losing too many of our young people. You know, I think of a house and I pray for those families and those people that declared the state of emergency. So we all know children and families is probably the most emotional issue on the planet. And because we carry such a deep love in our hearts for our children. So I look forward to Mary Tichy, another incredible, strong spirit in this. I very seldom go to AFN meetings, but when I do go, I love to see Mary go up to the mic. Yes, yes. So good to see Mary here. And with that, I just want to say I'm really honored to be in the presence of such good people and look forward to the next couple of days. White, Livnin.
Before we get started, I'd like to, on behalf of the Directors Forum and our Children on Waste Society, I'd like to start with some opening comments. And again, as I said, I'm very honored that you're here. Denise, Sekuze, Spaize, all our wonderful staff. I see some of them are here, some of the directors, and of course we have our beautiful matriarchs, Judy and Deb, that are guiding this work. There is so much information that you're going to have to absorb in the next few months because there will be a decision that has to be made around the proposed $47 billion projection. Now, if it was $47 billion that they were giving us, Cindy and I said, well, let's just take it and we'll put it in the bank. But there is no $47 billion that's there. It's a projection, just to be very clear. One of the things that Chief had, he's here, Chief Billy here, Haida Nation, brought to my attention, and then I started thinking about this. I really contemplated and ruminated over it. I think because, you know, we've been in this fight for so long, and you know, Cindy Blackstock and I, and Jessica now part of the Caring Society, that we know sort of the history of how we got here. But there are a lot of new leaders and new chiefs and are unaware of how this $47 billion came to be. So just in a real brief nutshell, like the $47 billion is attached to the fight that we started in 2007, the Canadian Human Rights Tribunal. It's not something that Canada said, hey, let's negotiate long-term reforms. It actually came from a long, long fight. So what happened, I'm just gonna give you a real quick rundown. So we had, of course, one in 2000, took the challenge 2007 to end discrimination against First Nations children because of the disparity between off reserve and on reserve. There was no prevention funding on reserve. At Carriacou County Family Services, I'm the executive director there. At the time, for 11 First Nations, I would receive either $17,000 or 1 year, $32,000 to prevent children going to care for 11 nations. So we had no recourse, we had to go to court. And so in 2016, of course, the big landmark ruling where Canada was found to be discriminating against First Nations children. But if you think about all the times after that we had to take Canada back to court again and again and again to follow those orders. Every time we've taken them back to court, we've won, and it's gotten better. So we, for example, you know, they weren't following the orders around Jordan's principle. We had to take them back to court for that. It ended up that, you know, now, the ruling after that was that not only did they have to pay for Jordan's principle for status, you know, non-status, but what was really key to that is that the nations themselves could develop a criteria and say who was a citizen to receive Jordan's principle, which was a huge win. And for those that are, you know, in treaty talks, you're talking about self-governing government, you can see how that would be the start of your citizenship, and the feds could pay for that work. So every time it's taken to court, it's gotten stronger. Now, back in, when was the first National Day of Truth and Reconciliation? So that's been 3 years ago, 2 years ago, 3 years ago. So on September 29th, we won another decision around capital, Jordan's principle. And some of you may recall that that morning when we won yet again, Canada was going to again appeal the decision. Later that day, Minister Miller came on and had asked, you know, would we negotiate instead of them going to court? Because imagine this, if they had again appealed that decision, it would have been on the eve of the first National Day of Reconciliation. It didn't look really good that they were going to take kids back to court on that day. So they did, and so they agreed to negotiate. So we agreed to negotiate long-term reform. Now, you'll remember, you know, just recently we have the compensation battle that we had. That compensation is so that to compensate the victims. So in the initial orders, you have the victims need to be compensated. This is First Nations children and the families, and to ensure discrimination ends and never happens again. So that's what we were negotiating. Compensation is already done. It's in the past. We're looking forwards, forward-looking. And so the long-term reform, that's what we're talking about. That's what we were negotiating. We're at the table, and we agreed to negotiate that long-term reform. And we did this through the agreement in principle. So one of the things that you have to note in British Columbia is that we did not receive any prevention funding until Canada was ordered to pay that. The rest of the country received prevention funding under the Enhanced Prevention Funding Framework that started in around 2007-8, around that time. So the rest of the country, for the most part, the Maritimes and up in the Yukon and BC were in a unique situation where we didn't have any prevention dollars. And so what that has caused is that we don't have a baseline. We don't know what it's going to cost for us in BC to provide prevention. Now, Chief Stuart Phillip talks about his great-grandchild, and to say, you know, no, we have to work together. How are we going to change that narrative of these sad stories? Well, we have that opportunity to do it right now. And that is so that we ensure that the prevention funding and the long-term reform that we agree to is going to make sure that his great-grandchild and those not yet born don't have to suffer discrimination again, and that there's money there for preventing the atrocities that has happened because of colonization and residential school. That's what we're talking about. It's very, very important. So you'll see, like, so the agreement in principle, we had agreed, we negotiated it. What ended up happening is while we sat there trying to get the best deal, we took advice. We were guided by the National Advisory Committee, which are child and family experts from across Canada. And we got advice from them, and they in turn got advice from the grassroots people, from the ones that were doing the work in the communities, the ones from the youth, from everybody, from the parents. That's who was guiding. That's the information that we were taking to the table. So good negotiations, if you're going to negotiate forestry, you'll have the best subject matter experts there. You'll have the best foresters, one would hope. So that's what we were doing when we were negotiating this agreement in principle. We were guided by youth, a lot of research and work that has been done, and surveys by the Institute of Fiscal Studies and Democracy to ensure that the work that we were doing was going to meet the need. So what ended up happening though, and again, and this is what I found that many of our leadership, especially in the last few weeks, weren't aware of, is that the Caring Society was not at the table when this deal was struck and finalized. The reason we weren't at the table is because while we were there in good faith originally, and you'll remember the nations themselves would receive prevention dollars. There was post-majority, all of that. That's the agreement in principle. So we were there at that time. So when we were going on to negotiate the final settlement agreement, Canada was not fulfilling the CHRT orders and they were not living up to their commitments at the table. They were acting in bad faith. And so we had these discussions with Cindy and the Caring Society, our lawyers, and really we were sitting there, yet they were still discriminating against their children, especially with Jordan's principle. And you all know, we've heard complaints from across the country. We've heard so many complaints in BC where those Jordan's principle cases are not being dealt with in an expedited fashion, where there's denial for no good reason. So we know there's issues there. So Canada was doing this while we sat at the table in good faith. So finally on December 8th of this past year, we had to file a non-compliance order. And so then we were forced off the table. We could no longer sit at the negotiating table. And that's why the Caring Society was not a part of these negotiations. Like, think about that. So at the negotiating table, we have Canada lawyers, AFN lawyers. We only have, like, for the most part, all the lawyers that are there, mostly non-Indigenous. And would you not think, just like I talked about forestry, you're going to get the best subject matter experts, that you would want Cindy Blackstock at that table? And we didn't have that. The Caring Society, even though we brought the charge, led the charge all those years ago, we weren't at the table. So again, that is what we're talking about today. And so we have a wonderful panel of experts, or that really, you know, we're going to look to them because they've looked at the final settlement agreement. It's a big convoluted agreement. There's a lot of things that we wanted, some principles that we wanted in there that are not in there. So we have to make some decisions here in British Columbia, and to help us get to a place where we could have a real fulsome discussion and come up with a real strong strategic plan. I'm going to call up Scott Smith from Arid and Veritas. Just wait, sorry, Scott and Paul. We're actually going to have Sarah Clark come up to the table. But Jessica, Saunders, and Cindy, if you could come up. We have a wonderful panel, and we're going to start with Sarah Clark.
Hi, everyone. Hopefully you can hear me. Wow, I can see my face on the big screen. That's very large. So first of all, I want to thank everyone for having me today. Apologies for not joining in person, but want to recognize the traditional territories that this is taking place on today. And thank you for letting me jump the queue. My name is Sarah Clark, and I am honored to be one of the lawyers for the First Nations Child and Family Caring Society. I'm jumping the queue because, as Mary mentioned, we are still continuing to fight on Jordan's principle, and I'm heading to Ottawa for those hearings this week. And I've got 2 young kids who I promised I would take to Granny's house for dinner tonight. So apologies for jumping the line. Just a little bit of a context. I have been supporting the Caring Society most of the way along. The case actually started when I was in second-year law school. And I had been working with Cindy as a social work student before that. So I really have had the opportunity to see what the government has done, what the government has said, and actually how it's impacted kids on the ground. So my hope in the very short amount of time that I have today is to really point to 2 issues around the final settlement agreement that I think are really important for your consideration as you're coming to a decision on how you want this agreement to move forward and how it's going to potentially impact the children in your communities and the families that you're supporting through the work that you do. So probably the most fundamental finding of the Human Rights Tribunal was, as Mary said, around the lack of prevention funding. And I'm going to focus my comments around prevention, specifically on British Columbia and the impact of what was called Directive 20-1. In British Columbia, agencies that were serving First Nations kids on reserve were not receiving any dedicated funding for prevention. They were receiving 100 cents on the dollar to remove children and place them in foster care, but they were not receiving any dedicated funds for prevention. And so what that meant was, if a family was struggling, if kids were at risk, if the agency needed or wanted to put services in the home, the only way they could really do that was to remove the child from the home. That was the only way, and the government would pay for that. So what actually ended up happening, and is found by the Human Rights Tribunal, was that there was an incentive to bring children into care in order to give them the services that they were entitled to receive. So one of the fundamental findings in 2016 by the Human Rights Tribunal was that the government's funding formula was actually creating an incentive to remove children from their homes as a first resort rather than as a last resort. And that's right out of the decision from 2016. So that fundamental finding, I would say, was a centerpiece of what the Caring Society has been attempting to push forward in the way that we've been working with the government and the other parties. And there have been a series of decisions since 2016 that has ensured that agencies could access the prevention funding that they need when they need it. So in 2018, the Human Rights Tribunal ordered that agencies could access prevention at the levels that they needed. This is called the actuals order. You might see in some of the material that's floating around. The actuals order allowed agencies to access needed prevention funding at the level that they needed it. And then in 2022, that prevention funding became sort of earmarked to the kids and families that were being served by the agency. And that prevention funding was rolled out as a reflection of the research that had been done by the Institute of Fiscal Studies and Democracy that Mary mentioned. So what was very integral to any reform is to ensure that agencies can actually provide prevention services so that kids don't have to unnecessarily come into care. We know that some children will ultimately need to come into care. The work of the agencies is critical to the lifeline of children and families. And what we want to do is make sure that those services and supports are done in a culturally appropriate manner, are guided by the principles, the traditions, the culture of the community. But from time to time, we do know that those things need to happen. But so much of the work that the agencies can and want to do is grounded in that prevention, in collaborating with families, in supporting children when they are at risk, in finding community programs, services, supports, making sure all of those things are in place. And that work is absolutely critical. I think one of the things that we're very concerned about in the final settlement agreement is a complete lack of prevention to the agencies. And so the way that the funding is structured in the agreement is that the agencies will receive a baseline of the funding. And the research told us that the agencies would then receive a series of top-ups depending on what's happening in their community to ensure that services can be provided at the level that is necessary. Unfortunately, what the agreement does is it pulls that funding apart. And it allocates certain pots of funding to First Nations and certain pots of funding to agencies. But what they've actually done is, instead of listening to the voices of the researchers who worked very closely with First Nations and First Nations agencies, they're actually pulling the pieces of the funding structure apart. And so we're very worried that it's not going to have the results that are intended, which is to reduce the level of children in care, provide culturally appropriate services, and make sure that kids have every opportunity to be healthy. So under the final settlement agreement, the prevention funding is completely being allocated to First Nations. And then First Nations can, if they choose, direct that funding to the agency. And I think the concern that we have, and actually we heard even in the opening comments today, that First Nations themselves are in many places across the country and certain places in British Columbia in dire need of supports. So of course, First Nations need funding to support their children and their families in their communities. And hopefully they will use that funding in a good way to support kids. But what's happened under the agreement is that agencies now are back in the exact place that we were in 2007 when we started this complaint. They will have no funding to deliver prevention. Now, the government will say, well, the baseline that they're going to get will take into consideration some of that prevention. But in my view, that's not really an answer. Actually, what they're repeating, and when I went back and looked at the decision from 2016, they're actually repeating a lot of the same things that they said when the case was first brought. So there is a very, very serious concern that agencies will be in the same position that they were in before, which is the only way that they can offer service is really to bring children into care. Another thing that I think is very important to keep in mind is that since 2007 to 2024, social work practice across the country has evolved, and there is more emphasis on prevention. So under the new federal child welfare legislation, an act respecting First Nations, Inuit and Métis children, youth and families, everyone, we all call it C-92. Under C-92, there's actually a higher emphasis on prevention than there was before that legislation came into effect in 2020. So agencies actually have more work to do. They have a higher legal standard to demonstrate that before they're doing any intrusive steps within the family, they actually have to lead with prevention and be able to demonstrate that in court. Our concern is that how are they going to be able to do that if they don't receive any prevention funding? So this is a bit of the concern. We have not seen a yes and approach from the government. They obviously had that opportunity. There is an opportunity to take a yes and approach to prevention. These children and family need all kinds of support from every angle, but agencies have a very unique perspective, and they are there to perform a very important role in our communities to make sure that kids stay safe. So I would say from a fundamental perspective, this issue of prevention is very important. So I think you need to, in your thinking and in your times of reflection, go back and consider this piece around prevention. The other thing I will say about prevention as a lawyer, and I don't mean to be all lawyerly on you, but I do have a worry about downloading prevention onto First Nations from a liability perspective. Most child welfare legislation, including in British Columbia, has certain protections for workers on an individual basis when they're delivering service. That is not the case for First Nations, who are going to be ostensibly delivering prevention services under the rubric of child welfare. So that collaboration between First Nations and agencies is very important, but I worry that really what Canada is doing is downloading responsibility of delivering prevention services onto First Nations. And that can also cause liability problems, which I won't get into too much, but there is a risk there that if First Nations are delivering prevention, that there could be liability considerations. So that's something to think about. The other very quick issue I'll just point to is First Nation representative services. So under C-92 and under the Child, Family and Community Services Act, First Nations have certain responsibilities and opportunities to participate in child welfare cases and in child welfare proceedings that ultimately go to court. In Ontario, under the final settlement agreement, Ontario First Nations are going to receive millions and millions of dollars in excess of what every other First Nation in the country is going to receive. And that's because the tribunal had ordered that for Ontario First Nations, starting in 2018, they could request from the government the actual costs of collaborating with agencies, working with agencies, and going to court when there were child welfare cases in court. Those First Nations are going to receive a baseline based on what they've spent since 2018. So for some larger First Nations in Ontario, and even smaller ones, who have been accessing the actuals order since 2018, the baseline that they will receive will be, in some cases, in the millions and millions of dollars to deliver First Nation representative programs. That's not available in the rest of the country. Under the final settlement agreement in the rest of the country, First Nations will receive a per capita amount, which is roughly $283 per on-reserve community member, and with a minimum of $75,000. So that number, again, is not tied to need. It's based on a mathematical formula that the government has decided for the provision of First Nation representative services. And the tribunal has always said that really, in order to demonstrate that the discrimination has been mitigated and that we will not be in a place where we are repeating the discrimination, funding has to be based on need. It has to be based on evidence, and it has to be based on need and what kids need in order to thrive. So this disparity between Ontario and the rest of the country, and I'm an Ontario lawyer and I represent First Nations in child welfare proceedings when I'm not working with Cindy and Mary. So I know how even under the current process for Ontario can be a struggle, but I do see a disparity there that I think is very concerning. And the last thing I'll say in my 1 minute, because I know we're on a tight timeline today, and you might and hopefully hear this from others, is there's a real lack of enforcement of this agreement. There's actually a clause in the agreement, and I imagine others will point to this today, and that's 384. So if you read nothing else in the agreement, I really recommend taking a look at paragraph 384. If the government does not procure the funds, if Parliament does not procure the funds, there really is no main enforcement mechanism. What the agreement says is that an aggrieved party can go to a court of competent jurisdiction, and if allowed by the court, we can reopen the human rights complaint. If this agreement passes in the way that it's currently constructed, we will be saying goodbye to the Human Rights Tribunal for child welfare. And if the government does then not procure the funds that are promised in the agreement, it will be a very long road in order to enforce what's actually in the agreement. We will have a very difficult time somehow trying to get the Human Rights Tribunal to come back and make the orders that kids are going to need in order to thrive. So I would just really take a minute and really reflect on that. That's the nervousness of this agreement. If we walk away without an enforceable final order on embedding the structure into the system, it's going to be a bit of a challenge. So I will leave you with those comments. I want to thank you again for hearing me today and for letting me come on the Zoom and going first. And I'm going to sneak out early only because of the time difference. But thank you, everyone. And if there are questions, I'm sure Tracy or Mary can flip them to me. They have my contact information. Thank you so much.
Thank you, Sarah. I am, you know, and as far as lawyers go, that I can listen to Sarah all day. That's quite amazing.
Yeah,
Thank you so much for
they are arguing the historic principle case.
yeah, that's right too. And you have to remember that all of the pro bono work that they've done, and it's amazing. And then you look at some of the legal fees that were procured by the lawyers around the compensation, the tens of millions of dollars, but yet our lawyers did that pro bono and they already proved the discrimination. So just amazing, amazing work. And when I talk about those ancestors, what will the ancestors that those not yet born will speak of, definitely Sarah Clark's name will be on their list. So we have right now And thanks to Mr. Scott Smith, formerly Gowling WLG, has got a new home, Aaron and Meredith. And so Scott has been working with us off and on over the years, and kicking and screaming, coming and helping us with the child and family file, because really, when it comes to child and family, I always say this, you know, we have to protect our most important resource, and that's our children. And how do we do that? We have to look at how we're taking care of our children, protecting our children through an Indigenous rights framework. And so this is Scott's expertise, so I just really appreciate the work that you and Paul have done.
Yeah, thank you very much, Marion. I'd just like to begin with acknowledging that we're on the unceded, unsurrendered territories of the Musqueam, Squamish, and Tsleil-Waututh people, and thank them for allowing us to do this very important business here this afternoon. So as Mary mentioned, my name's Scott. When I coined the term Indigenous resource law, I didn't necessarily have children and families in mind, but Mary convinced me, as she would say, that our most important resource are our children and families. And so I've had the honor and privilege to work and walk alongside Cindy and Mary in this journey for a number of years, together with my colleague Paul Seaman from Gowling WLG, who's seated there to the left of Mary, and who's the National Practice Group Leader of Indigenous Law at Gowlings. So, yeah, that's okay. Pause here 1 second for technical difficulties. I'll get out of the way. Moving your way here. Okay, there we go. Okay, so that probably chewed up half of my time here. I'm going to be try and be really quick here. So Mary gave you the background. Essentially, what we're trying to do here is stop discrimination and ensure it never happens again. And we're trying to do this through a final settlement agreement. I'm going to talk about 3 or 4 key elements of the final settlement agreement. I'm going to come back to this, but I want everybody to be aware that the final settlement agreement requires AFN to promote the final settlement agreement and to procure your approval. And we're going to talk about what that means for upcoming AFN sessions. I'm going to talk about how the negotiation process that led to the final settlement agreement and the settlement agreement itself is inconsistent with legal standards of international law, the United Nations Declaration on the Rights of Indigenous Peoples, and I'm going to go through a few resolutions that were passed by AFN and BC AFN. And just, I want to stop here for a second. When I'm mentioning AFN, I'm mainly talking about AFN Legal Counsel. There's a difference between what's happening at the political level and what's happening at the legal level. And a lot of this stuff has been driven at the legal level. For example, our BCFN regional chief has been voting with a number of the chiefs trying to bring these issues to the forefront. So I'm going to talk about the potential for ongoing discrimination. I'm going to, like you heard a little bit from Sarah about funding. You've got Cindy Blackstock, who's the expert on this. I'm just going to touch on this, but I'm really going to focus on why the FSA or the final settlement agreement doesn't provide adequate mechanisms to ensure that funding shortfalls can be addressed and to ensure that discrimination stops and never happens again. For the chiefs in the room that are ultimately going to be asked to vote on this, I'm going to point out that there's no decision-making role for British Columbia in this final settlement agreement. A real subjugation of your Aboriginal title and rights, and I'm going to tell you how all this is occurring in the final settlement agreement. First and foremost, nobody from BC is a party to that final settlement agreement, which is part of the large problem. I'm going to talk a little bit about vague funding commitments in relation to C92 self-government agreements and treaties, and then I'm going to end with what's next. So I just wanted to, quick disclaimer today, I'm here doing this with Paul on a pro bono basis. and we're providing you with legal information. It's not going to be legal advice today, so you should get counsel from your respective lawyers. I just want to make sure that that's known. So I'm going to skip right away to one of the most important issues here, because AFN is going to be holding engagement sessions with the chiefs over the coming month or two. And I want to talk about what the final settlement agreement requires them to do. It requires them to promote it and to procure your approval, rather than to consult with First Nation leadership to obtain your free, prior, informed consent. So this should be of great concern to the chiefs. You'll see paragraph 379 from the final settlement agreement that I've reproduced that's on the screen, very clear as to what AFN is required to do. And you'll see this is in stark contrast to AFN's own resolutions, which required it to bring back options for the chief's consideration to seek your input and have an iterative process, open and transparent, to help get your input into the final settlement agreement. The other very disconcerting thing is there's a provision in the final settlement agreement that requires AFN to keep all discussions and communications in relation to the agreement in principle and the final settlement agreement confidential. So they're not going to be able to engage with you in an open and transparent way. And I'm now going to go to international law to tell you how these are fundamental principles that should not be violated. So my partner Paul and I were asked by Cindy to look at this issue from the context of international law. And what we can tell you is that victims of gross or systemic human rights violations, this is one of those instances. The funding discrimination that occurred and that was confirmed by the Canadian Human Rights Tribunal is this type of serious violation. So those type victims from that kind of violation have a right to reparation. And as part of that reparation includes the right to be consulted about and to participate in the development of measures to end the systemic discrimination. And the FSA, although it hasn't gone there yet, is supposed to be that kind of tool. So I'm just going to read you a quote from an international law source to give you a sense of how broad the conversation should be. So quote, institutional reforms aimed at preventing a reoccurrence of violations should be developed through a process of broad public consultations, including the participation of victims and other sectors of civil society. So I'd like you to compare that with what's happened to date, which has been a closed, private, confidential negotiations where drafts of the final settlement agreement were not shared with the chiefs, they weren't shared with the Caring Society, and they weren't shared with experts. Okay, so that sort of international human rights law, that gets codified in the context of Indigenous people in the United Nations Declaration on the Rights of Indigenous Peoples. And in particular, the Declaration enshrines the right of Indigenous peoples to be informed and consulted about matters through their own representative institutions chosen in accordance with your own procedures. So Article 18 and 19 of the Declaration are the most relevant articles. And I've given this presentation to Mary. She can circulate it to everybody. So you're welcome to take pictures, but you'll all get a copy of it. So I'd like to draw your attention in particular to Article 19. States shall consult and cooperate in good faith with the Indigenous peoples concerned through their own representative institutions in order to obtain their free, prior, and informed consent before adopting and implementing legislative or administrative measures that may affect them. And the FSA is one of these types of administrative measures. So Canada should be seeking your free, prior, and informed consent. And from my perspective, that involves a lot more than putting a final settlement agreement in front of the chiefs and asking them to endorse it. And that's what's happened today, unfortunately. There are other, in Canada, other obligations that apply in these circumstances. So the honor of the Crown is at stake, and Canada's fiduciary duties to First Nations are omnipresent in what's happening here. And from our preliminary review of the final settlement agreement, it appears to Paul and I that Canada is offloading those duties under international law pursuant to the Declaration, the honor of the Crown, and its fiduciary obligations to AFN, and that should not be happening. So you heard that language from the Declaration in Article 19 about representative institutions, and AFN could certainly be a representative institution. The challenge is that AFN hasn't followed the requirements the chiefs have established in accordance with AFN procedures. And I'm going to walk you through two of the key resolutions that set out what was supposed to happen. And unfortunately, the report card is a failure on all fronts. So the chiefs and assembly passed resolutions both at the AFN and at the BC AFN level. None of those resolutions have been followed. We're going to go through those in a second. So speaking of representative institutions, in 2006, the AFN Chiefs and Assembly approved the submission of the complaint by AFN and the Caring Society to the CHRT in 2006 or 2007. So that was what Mary was talking about that started this whole process. So despite this, as Mary mentioned, the Caring Society was inexplicably excluded from the final settlement agreement negotiations. So the very entity that was responsible for filing the complaint that brought us here today did not participate in the vast majority of the final settlement agreement negotiations. Okay, so let's go to the resolutions. The first resolution that I'd like to walk you through is AFN Resolution 40-2022. And you'll see in the middle column, everything is red, meaning that none of it has been complied with. So the first directive was no reduction in funding. You're going to hear from Cindy and others that there's a real danger here that we're going to receive less funding than you'd otherwise be entitled to under the CHRT orders, which are currently in force. Okay? We don't know what's going to happen after 10 years. The final settlement agreement is for a 10-year term, and there's really no commitments after that, those 10 years are up. So we could very much, under the current draft of the final settlement agreement, be in the very same situation that we're in 2007. In fact, you're hearing from Sarah, we may already be there. Second, First Nations Assembly must approve the FSA on long-term reform. It's very unclear whether that directive was followed because the language in the FSA is that it's contingent on the endorsement of First Nation leadership. I don't know what that means from a legal perspective. That's not the Chiefs and Assembly approving the final settlement agreement. Third thing, Resolution 6, Canada to fund First Nation National Advisory Committee to inform the FSA. So you heard Mary talk about the National Advisory Committee. That was the National Committee of Experts that was formed and created in order to provide advice on long-term reform. They weren't consulted about the final settlement agreement. In fact, the AFN stopped calling NAC meetings in February 2024, and no input was provided by the NAC. So Mary was talking about the analogy of forestry. In this context, your national experts were not involved in the final settlement agreement negotiations. 7, Canada provides chiefs with all, and I want you to pay close attention to this language, please, it's underlined on the slide. All available options and related supporting financial resources to ensure free, prior, and informed consent on long-term reform. So what that negotiation table was supposed to do was come back with a variety of options and how they could be financed. There are no options. You're getting a take it or leave it final settlement agreement. Ensure the final settlement agreement does not inhibit the right to seek CHRT orders. In fact, the opposite is happening. The final settlement agreement purports to do away with the tribunal's jurisdiction once and for all. And the question is, and you heard Sarah talk about this, given how weak the dispute resolution mechanism is in the final settlement agreement, how are we going to ensure that the discrimination stops and never happens again? Very unclear. Okay, so here in British Columbia, the chiefs at AFN passed a resolution entitled 07-2024. None of this resolution has been complied with. So first, AFN to ensure that First Nations title, rights, and sovereignty are acknowledged and upheld in any negotiations related to children and families. Well, I hate to tell you the punchline. There's no decision-making role for British Columbia anywhere in the final settlement agreement. How is that not subjugated your title and rights? You're not a decision maker at the table under the FSA. 3, AFN to share drafts of the final settlement agreement with the Caring Society, that National Advisory Committee that I talked about, regional experts, and quote, meaningfully incorporate their recommendations for change. No drafts were shared. None. 4, Canada provide funding for regional engagement on the draft compensation distribution protocol. Hasn't occurred. So when you look at what the chiefs directed happen versus what's actually happened, giving that report card an F, failure on all fronts. More concerning is there's the very strong potential for ongoing discrimination. So you heard Sarah talk about this. So as Mary mentioned, there are already a pile of orders from the Canadian Human Rights Tribunal that are in force and effect today. And the estimate that experts have come up with is that will require Canada to pay approximately $45 billion over the next 10 years. Importantly, there's no cap or ceiling on that. They have to keep funding at actuals, what it actually costs to deliver children and families. And I want to emphasize this, that funding under the orders is not at risk if the chiefs decide to reject the final settlement agreement and send it back for revisions. The orders will remain in place, the jurisdiction will remain, and the CHRT will continue to police Canada's non-compliance with its orders. So this is the status quo. There are no sort of scary risk scenarios here if the chiefs decide to reject the FSA in its current form and ask for it to be renegotiated. This is the status quo that would remain, and the funding would be required. And I was talking to Cindy in the airport on Friday, and I think that should provide the baseline for decision-making as to how chiefs are evaluating the final settlement agreement. Any final settlement agreement should provide you with more money than you would otherwise get under the orders and ensure that that money is going to be delivered and discrimination is going to end. And what you're going to hear from the rest of the panel is we're not there yet in the final settlement agreement, unfortunately. So you're going to hear a lot more about funding, so I'm going to go very quickly over this point. Very briefly, the experts have concluded that the funding may be inadequate, and you heard Mary talk about BC in particular, where we haven't yet established a true cost of prevention funding. Now, you heard Sarah mention that paragraph. Remember, she said if you read one paragraph, read this one. That paragraph says that there's no guarantees in any of the funding in the final settlement agreement. It's all subject to annual appropriations by Parliament or other approval processes required by Canada. And there are no mechanisms in the final settlement to deal with a situation where there's not an annual appropriation by Parliament. I'm not going to get into the legal subtleties of it. What's in there doesn't make sense from a legal perspective and provides no certainty. So we're not even sure that the dollars in the agreement are actually going to get paid. Okay, the final settlement agreement is for a 10-year term. What happens next? How do we ensure that we're not in the same spot that we were in 2006 and 2007? The agreement doesn't speak to that. Furthermore, Canada is not required under the agreement to provide any additional funding to First Nations, regional or sub-regional organizations beyond what is set out in the final settlement agreement. And you're gonna hear about the weakness of the dispute resolution mechanism. In my mind, it comes down to two things. They created what's called a dispute resolution tribunal. That tribunal does not have the authority to order Canada to pay more money or to amend the final settlement agreement. And it's going to remove the Canadian Human Rights Tribunal supervisory jurisdiction. CHRT is going to be out. That tribunal can't order Canada to pay more money. So what happens if we've underestimated the amount of money required to end discrimination? You're going to have no recourse under the agreement. I note for the BC chiefs in the room, there's no funding for BC here. There's tons of funding for the parties to the agreement, which include AFN, Chiefs of Ontario, and NAN. NAN's a political organization from Ontario, if you're not familiar with them. $22 million in funding for those organizations to participate in the Reform Implementation Committee, and $84.1 million for them to take part in the National Secretariat. So again, the National Secretariat, it's going to be set up by AFN, CHU, and NAN, no BC representation there. And AFN, CHU, NAN, and Canada are the only parties responsible for figuring out who's going to sit on the Reform Implementation Committee. So because there are no BC organizations or First Nations that are party to the final settlement agreement, you're not going to be involved in any formal decision-making once the deal is inked. As I mentioned, the membership of the National Secretariat is limited to AFN, CHU, and NAN, and the Reform Implementation Committee members are appointed by Canada, AFN, CHU, and NAN. So I just want to take a second here to talk about this Reform Implementation Committee. This is the main body for implementing the agreement. It's required to carry out its work confidentially, and none of the members can tell any non-parties what's happening. This isn't going to be a public implementation process here, folks. It's going to be an implementation process that's controlled by AFN, CHU, NAN, and Canada. That body is not required to consult with First Nations or leadership. So rather than having First Nations leadership continue to supervise and the implementation of the agreement, that's not going to happen. Those folks can't legally tell you what's happening in their deliberations. And that's the main mechanism through which any implementation issues get addressed. There's also an organization that's going to be retained to do what's called the program assessment. There are two of these things. One happens towards the end of the first 5-year period, and the other happens at a second 5-year period. AFN is going to be responsible for selecting that organization. That works fundamental because that's supposed to figure out if you're getting enough money or not. Also, because no BC organizations, Leadership Council, BCAFN, Summit, and the Union, not parties to the agreement, no BC First Nations that are parties to the agreement, you don't actually get to participate in any dispute resolution mechanism. So if you're a party to the agreement, there's two types of disputes. One's a parties dispute, that's like how the agreement's being implemented and funding issues. You're not going to be a party to those because you're not a party to the agreement. And then there's claimant disputes, so those can be brought by First Nations. You wouldn't otherwise be allowed to participate either. Only the parties can seek intervener status. So probably running short on time here. The main take-home message, Chiefs, is there's no decision-making role for British Columbia in the agreement. Now, what's even more concerning is under the agreement, any information that's, quote, provided, created, or obtained in the course of implementing the agreement must be kept confidential. So that means none of the information that comes about as a result of the agreement implementation can be shared with Leadership Council, BCAFN, the Summit, Union, or any of the BC First Nations. You can request additional funding if there is not enough funding being provided. Canada is not required to provide you with that additional funding. Last but not least, BC First Nations are essentially being treated as service providers, and your role is essentially limited to requesting additional funding. And if you don't get that, you can initiate what's called a claimant dispute. But to do that, you have to waive your right to go to the Canadian Human Rights Tribunal and file a complaint. So right there, you're in a conundrum as to whether you want to be waiving those rights. There's a more fundamental issue here that I want to talk about very briefly. This final settlement agreement embeds the role of ISK in a very serious way for the next 10 years. At least from my perspective, there's no making ISK great again. They need to be removed from the situation permanently. We need First Nations organizations like a First Nation Treasury Board and other organizations to receive the appropriations from Parliament and figure out how to get them to nations and the agencies that are providing care to your children and families. So I'll just leave you with that thought. That's a little bit more radical than the other stuff that I've been talking about. But I think it's a real problem that we're giving ISK more power under the agreement than it already has. In the interest of time, I'm going to skip over the dispute resolution process because others are going to talk to you about it. The two things you need to know is they can't force Canada to provide more money and they can't amend the agreement. So I don't see how this dispute resolution is working for First Nations. And when you combine it with the fact that they're trying to get rid of the tribunal's supervisory jurisdiction, it's going to lead to problems, right? You heard Sarah talk, you'll hear Dr. Blackstock talk about, you heard Mary mention about how they keep having to bring Canada back in front of the tribunal, dragging them kicking and screaming because they're not complying with the orders. So what happens when we get rid of the tribunal and we've got this watered down thing that they're calling a dispute resolution mechanism? So to conclude here, I'm probably over time, sorry. Yeah, one thing I'm guilty of is speaking too much. So there's a couple things that could happen. If First Nations leadership decides to approve the final settlement agreement, the next step would be for the parties, so that's Canada, AFN, CU, and NAN, to bring a motion to end the tribunal's jurisdiction and replace the CHRT orders with the final settlement agreement. So that's going to go before the tribunal. There's an opportunity for the First Nations Leadership Council, Summit, BCFN, the Union, and BC First Nations and agencies to seek to become interested parties and participate in the tribunal hearing if you don't agree with the ultimate decision that's made. If, on the other hand, leadership decides not to approve the final settlement agreement, it can be sent back for renegotiation. And hopefully I'm leaving you with the message that there's almost no risk in doing that, because probably no risk in doing that, because we already have the CHRT orders in place that are forcing Canada to deal with this issue. And I just note this, this happened with the final settlement agreement on compensation, right? So this isn't a scary proposition. In fact, it's risk-free. And, you know, I think one of the things you're going to hear more about is what some of those changes need to be. But that's the decision in front of you. And ultimately, I think it's going to come to a head in late October, early November at the Special Chiefs Assembly. So with that, Mary, I'd just like to thank everybody. I know it's a Sunday, but really important business. So thank you for being here.
Thank you, Scott. We are going to have time for discussion and questions later, so just take notes of your questions or if you need Scott to elaborate on anything more. So now I have the privilege of introducing Don Johnson from Mandel Pinder. Don?
Thanks, Mary. Hi, everyone. I'm Don Johnson. I apologize that I can't be there with you in person today as well. but feel very honored and grateful to be able to join all of you and for the great comments and presentations this far, and just acknowledging all of the incredible room and the work that has been done to get to this place, and that continues. Mary and Grand Chief and Hugh and all the others who've mentioned this work, and Dr. Blackstock as well. I just want to start. I'm Dawn Johnson. I'm a member of the Athabasca Chippewa First Nation in Northern Alberta, and I'm an associate with Mandel Pinder. I feel very lucky to be involved in this work. Previously had the opportunity to do some work with the First Nations Leadership Council for some time. And I just want to note, from a personal place, I come into this work not just as a lawyer. I think that's kind of the last place I come into it now, but as a survivor of the child welfare system myself, and as somebody who has raised my relatives to have them not have to grow up in that system in the way that I did, and with a very personal connection to this work as well. And in fact, that's what took me to law, was recognizing that I needed to learn this language if I really wanted to be able to advocate with and alongside so many of you and my siblings and other survivors from CARE. So with that, I know that we don't have very much time, and there's been a lot of really great information that's been covered already. It is a very complex agreement and a lengthy agreement, nearly 200 pages. Mandel Pinder has created a bit of a summary and a one-pager and a presentation for the First Nations Leadership Council. And I encourage you to reach out to the FNLC and some of their representatives to have that information sent over as well, because it goes into a little bit more depth. And I think, there's so much information within this agreement and challenges and topics and issues to really digest, that as much information from as many sources as you can get, I encourage you to do so. I'm not going to speak for or against the agreement, because I really believe that it's up to First Nations and rights and title holders themselves to decide whether or not this is something that works or doesn't, and what the next steps are for individual First Nations and for First Nations in BC. I'm going to focus primarily on that BC perspective, just because I think that is really important considerations that we need to have here in this region. And jumping off of some of the pieces that Scott in particular had highlighted during his presentation, and Mary as well, and Hugh and Grand Chief, and those great introductions. Recognizing that in BC, that it is a different picture. There is a different context here that comes from that place of BC not receiving that prevention funding for so many years, and the last of all regions across the country, which does present a bit of a different picture. And then also on the other side of things, the long-standing, really incredible and powerful work that has come from BC and First Nations leaders in BC in terms of advancing jurisdiction and self-determination and rights and title, in particular in the area of child and family services. And so, that place that you continue to hold in bringing this work forward. On that note, one of the things that is a reality is that the BC region has been historically and continues to be notably absent at the table. Keeping all of these pieces in mind, there was a lot of evidence that was presented forward prior to the discrimination finding by the CHRT in terms of the unique position in BC. And, you know, Mary and Dr. Blackstock really have that background and that history. But that was the only way that BC was present in those initial proceedings and since that time. And at the negotiating table, the unique and distinct perspective and challenges and strengths of the BC region are also absent and continue to be in the way that the settlement agreement is currently drafted. And so, as Scott had mentioned, there's these governance structures that are built into the final settlement agreement, one being this national secretariat that is comprised currently of the parties to the agreement. So that's the National AFN, the Chiefs of Ontario, and Anishinaabe Aski Nation, who would form this First Nations led, this is how it's drafted in the agreement, that it's a First Nations led national secretariat. However, it's a First Nations led national secretariat that is made up of AFN, Ku, and Nan, and all other regions, including BC, are absent from that current structure. I've heard in some of the presentations that AFN has been doing over the last few weeks since the settlement agreement was announced, that they're hearing that this is an issue from other regions, and they're taking that back to the negotiating table, but would suggest for nations here in BC in particular that there is redrafting and amendments within the agreement that reflect a space for First Nations in BC at that National Secretariat. And then also branching off of that, this Reform Implementation Committee that Scott had referenced. So the Reform Implementation Committee is really this oversight body that looks at how the agreement is being implemented, whether or not it's working, what some of the challenges are. If there's issues, that goes to the Reform Implementation Committee, who then gives recommendations on how to resolve those issues, both at the nation level, the agency level, and then at the regional level. I mean, they hold all the power. It's not just a lot of power. They hold all the power in terms of determining how the agreement is being implemented and whether or not it works. And so if the agreement is to be passed and there's amendments that nations in BC are really pushing for, those are some of the areas that we really highlight and encourage you to look at and be pushing for, that there's not just regional representation, but recognition from that inherent rights place, that self-determination place, that it's the nations themselves, your nations here in BC, that need to be represented and driving how things are rolling out on the ground here in BC. So going back to that national secretariat, there's also a piece that says that these regional secretariats will be established. However, within the agreement right now, as it's currently drafted, those regional secretariats, where they're going to be located is determined by AFN, and not just what regions they're in, but also what type of organization. The language actually says an existing organization. So AFN would determine which existing organization in BC would house a regional secretariat, assuming they determine that there should be a regional secretariat in BC. And our suggestion and recommendation around that is that it's this really needs to be flipped on its head. Currently, it's very top heavy, it's top down. All, you know, from that national level with AFN in Canada in particular, down into the regions and then to the nation level. They're dictating and determining how things are going to be rolling out and what that looks like. And so there is critical importance of ensuring that the BC region is being represented in a substantial and meaningful way. Scott had also referenced these program assessments that are built into the agreement. So this is a review process, looking at how it's actually working, if it is enough funding, if it's changing the trajectory for First Nations children actually ending up in or remaining in care, et cetera. And so that goes through the Reform Implementation Committee and this 5-year program assessment, and there's these inputs it's being fed into by these subcommittees and technical advisory groups, that there's no BC representation on at this point in time, the way that it's structured and built into the agreement. There's no assurances or confirmation that BC will be represented in those ways, at those tables in any way. And so we see that as a huge concern and issue that you're going to want to be looking at and be considering as you make decisions around the agreement and advocate for particular changes. Another piece that we wanted to highlight was around, first off, the agreement is backdated. So currently it begins April 1st, 2024. So it's a 10-year agreement as of April 1st, 2024. And Canada has indicated that they've already started to roll out funding under the agreement as it's drafted. So it's not that it will begin after First Nations agree to it. If it's agreed to, it's already being rolled out in this way. The clock's already ticking. And on that piece, one of the key issues that we wanted to highlight is the reduction in capital funding. And so per the CHRT, nations are funded at cost for nations and agencies, for capital infrastructure and projects to support the delivery of First Nations Child and Family Services, including those feasibility studies prior to actually breaking ground. And we know and we've heard that there's been issues with the rollout of that funding, and nations in particular and some agencies as well being able to access that funding to be able to replace or develop capital infrastructure for the delivery of child and family services. And so that at cost funding in the current agreement is set to end on March 31st, 2025. So at the end of this fiscal year, capital projects would no longer be funded at cost, and they would be funded pursuant to the final settlement agreement, but also pursuant to some form of a process that hasn't been developed yet. It's not included within the final settlement agreement. The agreement says that it is to be developed by the parties by September 1st. As I'm not sure, I haven't seen anything as of yet. I'm not sure if others can speak to that. But we're saying, one, to be aware of that, and two, that this aspect of the agreement as well should not be necessarily agreed to until you have the full picture, going back to that place of full, free, prior, and informed consent, being able to agree to something that you have the full picture of, you understand what it's going to look like, how it's going to roll out, but then also, because that clock is already ticking, that the March 31st, 2025 deadline for at-cost capital to end is not reasonable or realistic for First Nations. The other piece that we wanted to highlight around that is, as of yet, as far as I'm aware, there has not been a breakdown of the funding by region or by recipient type. And this is one of the pieces that IFSD has recommended, the Institute for Fiscal Studies and Democracy. This is one of the pieces that's really important, again, to understand. One of the questions is this enough money? Like, are we going to have enough funding and resources to be able to do this very important work and ensure that the delivery of child and family services is changing in a positive way for First Nations children and families? We don't know what that looks like in BC as of right now. How much money lands in BC and where it's going and how that rolls out, and whether or not that aligns with what's being recommended by IFSD and other experts who are doing this work. The other piece I'll touch on really quickly, Scott mentioned as well that currently First Nations are being identified within the agreement as service providers. So service providers are defined in the final settlement agreement as First Nations Child and Family Service agencies organizations that are designated or delegated by First Nations to deliver child and family services, and also First Nations themselves who are delivering child and family services. And so we say that that definition, by including First Nations in the definition of service providers, is really contradictory to what's stated in the purpose of the agreement around recognizing inherent rights and recognizing First Nations as governments, and that needs to change and is not an acceptable aspect of the agreement. And then the other piece, just recognizing I've got about a minute left here, I'll touch on briefly, and I'm hoping that Dr. Blackstock or Jessica may speak to this as well, is the dispute resolution tribunal that's established. And so Scott had mentioned there is this dispute resolution tribunal that's established by an order in council. They're saying that there will be legislation, enabling legislation that's developed to establish this dispute resolution tribunal. It's going to be led by what's labeled in the agreement as a president. The president will be appointed by an order in council. I've heard AFN saying repeatedly that they expect or intend for this person to be a First Nations person who is a retired judge or somebody who has experience in the area of child and family services. And that's kind of the end of it. We don't really know too much else in terms of one, you know, how they came to this place of deciding that this is how the dispute resolution tribunal should be established, or if there is already some form of a sense in mind as to who is going to be appointed as this president. And there's no role for First Nations yourselves in order to determine whether or not that is somebody that you want appointed in that role, or to have any say in the development of legislation or the development of the tribunal and the tribunal process itself. It does end the jurisdiction of the CHRT, with the exception of, it does state that if there are issues of discrimination, that can be a complaint can be initiated before the CHRT. That would be a new complaint. As was mentioned earlier on by Sarah, if there are issues around the receiving funding, adequate funding from Canada pursuant to the agreement, that allows one of the parties to the agreement to initiate, well, first to seek an order from a court of competent jurisdiction, and then if that order is granted, to reopen the complaint before the CHRT or to initiate a new complaint. So that's the end of the tribunal's role and jurisdiction in the oversight of the agreement or this area. The dispute resolution tribunal as well, it's binding on parties. So nations or others who are receiving funding through the agreement, who choose to seek dispute resolution before the tribunal, this newly established dispute resolution tribunal, the decision of the tribunal will be binding. It is only regarding matters that connect to the implementation of the agreement itself. And so I attended some of these presentations from AFN, and one of the questions that I had heard at a recent presentation was, does it apply to disputes between nations and their agencies? If there's in areas where there may be tension or conflict between the nation and the agency, the answer was no. That is a place where Canada continues to have the authority and the role. And so just to keep that in mind as well, that the dispute resolution tribunal is really only around implementation of the agreement and the funding that is already within the agreement. So you can't seek more funding through the dispute resolution tribunal. Recognizing that I'm out of time here, I'll probably move on. One of the things that, sorry, that I'll just add as a consideration, because you know, there's pros and cons to remaining with the CHRT. And again, I don't want to say for and against the agreement. One of the things that I have heard, and I think that it is important to be aware of, is that there are some pieces in the agreement that aren't included in the current orders of the tribunal. Most of it is. I want to acknowledge that. And I'm hoping maybe Cindy or Dr. Blacksack or Jessica may be able to speak to this as well. And one of those pieces is there is this housing fund that's included within the final agreement that provides for housing infrastructure. So what renovations, repairs, new builds for the first couple of years of the agreement. It's not for the entire 10 years. That is a new addition. I would say a positive addition. We know that housing is an ongoing challenge and issue in terms of child and family well-being. And so I would say that is one of the highlights, one of the positives within the agreement. That isn't covered under the current CHRT orders. And I mean, there's a couple of other smaller pieces as well, but I do want to plug that a little bit because I think it is important in terms of having a full understanding. But there are a lot of things, most of the things are covered by the CHRT orders. And I know the real experts in the room on some of those pieces will speak to that. So that's where I'll end my piece. As I mentioned, we have created some summary materials for the First Nations Leadership Council that I know that they want to ensure First Nations leadership in BC has. So to reach out to them and get that information, and I'm happy to answer questions if you want to reach out to me afterwards as well. Thanks so much.
Thank you, Dawn, for that. Again, we're gonna have time for discussion, questions and answers at the very end, but before we move on, I'm gonna suggest that we take a 5-minute break, a real 5-minute break. There's coffee and cookies back there. They're really yummy, so if you need a sugar fix, I'm waking you up. So we'll be back in about 5 minutes.
I know, right? Yeah.
Yeah, but so if we could create council, I think that will alleviate a lot of tension. Everybody. So we would have less safe. Okay, we're gonna get started here with less police service. With Jessica. And most of our programs, delivery services are regional, and they only come in as needed. They're not there for the session. So Jessica has been part of the Caring Society now for 2 years. She's a little newbie. So they can find. We're so fortunate to have her as on our society. So we're gonna leave the floor to you, Jessica.
Thank you. Good afternoon. I again want to acknowledge the territory we're on, acknowledge the director for starting off our meeting in a good way, and acknowledge the chiefs and experts, elders, everyone. Thank you so much for inviting us to your beautiful territory. My spirit name is Woman Who Stands to the North, and my English name is Jessica Saunders. I'm a member of Opaskwayak Cree Nation. I'm from Cranberry Portage, Manitoba, and I practice through my own law firm, Saunders Delaron Law in Winnipeg. And I just want to say it's such an honor to be here because I grew up, hearing about BC, when Splatson Nation, of course, went around with, the work that they did in the 80s, right? And then I grew up watching everything. I'm a witness, the Caring Society, right? When I came up as a young lawyer, I watched this work. It informed my legal career. When I was a junior in the Phoenix Sinclair Inquiry, we called Dr. Blackstock as an expert at that time in 2013. And I read, the Haida Gwaii, the Haida Nation cases. And so to be among you as leaders in child welfare and in so many other areas is just such a distinct honor. I'll just qualify as my friends have that this is, of course, provided for information sharing purposes and isn't legal advice. It's kind of my insights, and I really had to focus the discussion because it's so big and I could just go on and on and on, but I really tried to focus into areas I think that would be the best use of our time together today. And has been said by so many others, I'm a community person, I'm very visual. This, of course, is about, as you've heard, eliminating discrimination, ensuring that it doesn't happen again. So those two, right? Again, I'm so visual, so clear as day. And I just wanna, there's some words and some things that the tribunal and others have said. And of course, the reason why the tribunal is able to say these things is because they heard masterful evidence put together just through, just the tireless efforts of so many. The Caring Society, right? You had your own, Chief Joseph, who appeared before, the tribunal, Mary, Cindy, so many others from your territory here that, provided evidence so that the tribunal could speak in these terms. And so they've said things like, complete justice will be achieved when systemic discrimination ends and no longer exists. So the marching orders were quite clear. A few other words, of course, that they said when they were talking about compensation, talking to the magnitude of the harms that were inflicted on First Nations children, families, and nations. The tribunal has said the cycle of harm must be broken, right? That was when they were looking at the compensation final settlement agreement. And that was after that went through the ringer too, because as you remember, as has been said in Mary's eloquent, overview of things, they didn't get compensation right when they had their draft FSA. And it took people coming together, like the experts at the Caring Society, saying, it doesn't include everybody. Yes, it sounds like a lot and you've done the work, but it doesn't include everybody. You have to make sure everyone's included. And the tribunal agreed. And at that time, Canada was actually, in trying to go lower than the tribunal's orders. The tribunal was appalled and said, we've never seen this before. Mm-hmm. They're a human rights tribunal that was set up under, it's quasi-constitutional legislation. They were set up by Parliament to look at discrimination claims. And when they saw, they said, this is, the biggest claim, it's harms of the worst kind have been done to First Nations. And when Canada was showing up trying to settle with our kids and our families for less than what the tribunal ordered by law, they were appalled. They said, and honestly, in what world does that happen? Do they do that in employment law? Do they do that, when it comes to gender discrimination? But they do it to First Nations. So there we are at the Canadian Human Rights Tribunal, and they're trying to go below what the tribunal ordered, and that was on compensation. So who do we ever have stuff to talk about? Because I think the tribunal, they've probably already started reviewing it, but they're gonna see some things again. And I'm alarmed because there's things that I think they're doing where, again, it's like, in what world? Why do you think that you can do this to First Nations, right? So there's a few other things that, we have to go through and really hold them to account. But just on some of their wording, again, so important. They say things like a complete reform. They say the elimination of the systemic racial discrimination found and the need to prevent similar things from happening again is going to take a complete reform. We're not seeing a complete reform, as you've heard everybody speak to. This is not a complete reform. This is more of the same. The discriminatory practices, we need to make sure Canada ends them. And they're wording, again, a transformation that will protect generations to come. And I'm very proud of the Caring Society, because the Caring Society has done things like taken certain principles like, the 7 generations, right? And these principles in the Caring Society's, position on long-term reform that spoke to intergenerational equity, that it's, again, as Grand Chief says, for his little great grandbaby and Mary, those that come, after. We don't sit at the table just for ourselves, we sit for the ones that come after. And honestly, so when the tribunal hears us speak to those things in evidence and then says things like this, and then you have AFN and COO and NAN, reportedly First Nation, entities that are representing the interests of all First Nations, right? And they're missing it. They're totally missing it. So I just want to highlight those terms where the cycle of harm must be broken, complete reform, a transformation that will protect generations to come. This one too is big. So this was just right from the merit decision. First Nation children and families were denied equal child and family services and treated differently in the provision of CFS, contrary to Canada's Human Rights Act. That was done by underfunding the First Nation CFS program in the manner that it was designed, managed, and controlled. So many times that I've gone through this provision, these draft, provisions in the FSA, and I've thought, in what other areas would they do this to anybody else? And here they are doing it to First Nations. And again, design, manage, and control. That's what did it. And this whole FSA, just like, oh boy, it amps up just more of those issues in the way that this thing is designed, managed, and controlled. And when I review things, I'm very much guided by my own teachings. And it's an elder from Opaskwayak Cree Nation, Nichisan Irene Young, and she talks about the Intwysaniwin, and that, like, it's kind of, I guess, the interpretation would be Indigenous peoples, but it's everybody. Yes, there's, Squamish and, Cree and Anishinaabe, but Intwysaniwin is all of us. When we get that one term to refer to all of us in Intwysaniwin, and Mama Withuwin is bringing everything into unity in the Cree language. And so I always keep in mind, unity. And so when I'm reviewing, this agreement and I'm looking to how it's supposed to be, we all have our unique situations, absolutely. But I'm looking and I'm seeing how much unity is needed, and I'm seeing how much that the parties who negotiated this departed from unity and from, their own teachings, right? And of course, I'm very like, oh gosh, when I like art, right? I'm so much about art. And so when I heard certain things that some of the lawyers were saying, because this isn't personal, this is so bigger than any one person. This is, and I tell people it's not about, the national chief or this and that, right? If you focus on the issue, you'll see it. You'll absolutely see it. And in Manitoba, because that's where, the current national chief is from, you know, there's a lot of, you know, internal battles of, oh, we should support this agreement, and you're hearing Manitoba now come out and say they're seeing it because they're looking at the issue, and thank goodness, because it wasn't always that way. But this is a subjugation of truth, and it's by an Anishinaabe artist from Winnipeg, Ken Funkman. And the painting has Mistahi Musqueam, Big Bear, and Poundmaker. And you have Canada there, you know, with, you know, forcing Simon Penn, you have Sir John A, and you have, you know, the RCMP and the church, and you have them just looking at each other. And of course, the history from Treaty 6 was when Canada went around trying to get the Cree to sign Treaty 6, they, you know, and at that time it was, well, we know the number of treaties, surrender the land and you get reserve land. Surrender the land and you can pick reserve land. So Mr. Musqueam said, okay, if that's what we're stuck with, then he rallied to get everybody, all of the Crees, 2,000 Crees gathered, you know, together to come together and say, okay, we're not gonna, you know, divide and conquer, we're not gonna go all over, we're gonna unify, unity. We're gonna come together to have this land base because we're stronger together. What did Canada do? No, they punished the people for standing behind Mr. Musqueam. They cut rations of food when there was already struggles with the decline in buffalo. So they starved the people and then they threw them in jail. And so we know how Canada has done things. That's part of, you know, as Cindy says, we have our histories. Canada also has its history in the way it does things. So this to me was just, oh, because I also see people like Cindy Blackstock and Mary Teegee that have been our unifiers on this. When AFN first tried to, you know, settle this thing for $5 billion, it was Mary Teegee and Cindy Blackstock, right? And how many times they went after her. They literally went after her. She got damages from the Canadian Human Rights Tribunal because Canada, you know, was harassing her. But it didn't matter. They couldn't put her in jail, but they harassed her and she held them to account. So our unifiers are out there, they're doing everything they need to do, right? And I'm so very proud of that fact, and so would they. So as part of the review of the draft FSA, I'm just gonna say some pretty key things and then go through the agreement and show you the gauntlet we're gonna have to go through if this thing gets approved. So the draft FSA, and this is putting it nicely, is soft on Canada's discrimination. It's soft. I don't know, I'm a community person, that's putting it lightly. Soft on Canada's discrimination. This whole agreement is tailored to Canada, and in my view, it's rotten to its very core. I don't, you know, we were just talking about, can we do revisions? Should we be coming here suggesting like things you need to revise, right? I don't know, you know, and so that's kind of the thoughts that are a lot of people like that I've talked to and at this table have been speaking about, but equitable, fair, reasonable, non-discriminatory provisions that are needed to protect children, families, and nations. Like we know from the experts what's needed, and we know from this review, our review of it, that those provisions aren't there. Again, tailored to Canada doesn't go far enough in holding Canada accountable, and it will perpetuate discrimination. It creates a divide between First Nations CFS agencies and nations, and it does so in order to distract from the ultimate thing, which is Canada's accountability, which is the fact that Canada is the one that's been ordered to end discrimination and make sure it doesn't continue. But yet there's this whole, you know, theme of just like agencies versus nations and divide and conquer, right? That's exactly what's happening again in this agreement. So, and again, these are just some points. I don't have time to go through everything, but I'm going to focus the issues on funding, of prevention and results funding, and the issues that come in the projected shortfalls in those funding areas, and then the gauntlet that agencies and nations will have to go through if there isn't sufficient funding. So again, just to show how this whole process is tailored to Canada and doesn't hold them accountable. So again, we have this right from the preamble. The focus is on First Nation agencies being accountable to First Nations versus Canada being accountable to children, families, and nations. It started out with, you know, this unified approach in 2007, where you had nations, you know, as represented by AFN at the time, and the other parties, and the Caring Society and the same canoe. Then that divide, you know, becomes stronger in recent years. And we can kind of look to see where exactly in time that divide started happening. And it is when you get a change in, you know, the negotiator, and you can see, you know, where that kind of just veered off. The focus is on First Nations as the recipients of funds and not on Canada funding fairly and equitably to eliminate discrimination and prevent its recurrence. So you've heard National Chief in the media say, you know, nations are getting dollars and nations know best. And, you know, the crazy thing is she's not acknowledging that her whole agreement creates a divide, and it separates everybody, so that ultimately who's going to suffer are the gaps that have been created, and it's the children and families that are going to suffer. Because the clients I work with, when it's agencies and nations, when there's a crisis at the nation, and I can appreciate this isn't the case for everybody. Yes, there is that divide, I absolutely know that. But when something goes down in the community, right, the chiefs, the leaders, the matriarchs, everyone's calling each other like, can we get this? How do we do this? You know, can pull together unity around those things, right? This agreement just exacerbates the issue and creates more dissension when we need more unity. So I just think it was also negotiated by people who don't understand us and that reality of when something goes down in the community, and you have community people and leaders that are working together with their technicians to try and deal with this on the ground, doesn't factor in those on the ground realities. So the preamble, when you look at this thing, it's written by Canada. It's not what you would expect in a historic settlement to repair what the tribunal called harms of the worst kind to First Nations, children, families, and nations. The discrimination provisions, anytime they mention discrimination, they're always so clear about saying the discrimination found by the tribunal. It was found by the tribunal. It's never just discrimination, you know? It's, oh, the tribunal found it was discrimination. And the IFSD confirmed to us that Canada's representatives told them they never would have done this if it weren't for the CHRT. Canada never would have done this. And it shows all their language they use in that agreement, it shows, they take that tone. It's not complete reform because they still haven't acknowledged, they still haven't taken accountability. So how can they take responsibility? How can they act on their responsibilities? Especially when it's the most sacred responsibility that we all have to our children. The provision that just kind of glared out to me that then set the tone for the rest of the provisions I was reviewing, the preamble says, and whereas the accountability structure built into this First Nation CFS program is intended to ensure First Nation CF agencies are accountable to the First Nations governments and communities they serve. Again, accountability, that whole accountability structure was supposed to be about Canada being accountable to children, families, and nations, right? Another thing that kind of ticked me off, and I just kind of put it there, is they say, you know, the parties to this agreement that negotiated in Canada, AFN, Kuinan, you know, that this is a record of the necessary steps and actions and the embodiment of their best efforts to eliminate discrimination. We didn't ask for your best efforts. You're required by law to end discrimination. So I really think we have to hold them to account. Best efforts wasn't what was required, and we're just, now we go and look at the funding. So the funding, prevention funding, is going, as Sarah mentioned, right? It's going to be allocated to First Nations at $2,603.55 per person on reserve. That's going to be adjusted for inflation and remoteness, plus a minimum of $75,000 for each First Nation. So now nations can choose to transfer their prevention funds that they get to their First Nation agencies. I just want to note that this is, again, prevention is full circle, right? Primary prevention. So workshops, cultural and recreation activities, well-being activities for the whole, right? Secondary prevention, home visiting, mentoring, reunification supports. That's huge. Tertiary, crisis intervention, intensive family preservation services. If a child is having, or a youth is having, you know, a mental health crisis, right? You need to help them. You can't just, you know, again, the legal requirement that we prioritize prevention over protection. We can't just apprehend those kids. We have a legal obligation to provide these prevention services. So it's those three levels and it's full circle. In an AFN information session, after my friend's presentation, it's an information session, or kind of like a traveling roadshow, right? To get First Nations agreement to this final settlement agreement. but they were in Winnipeg from August 19th to 21st. And they changed in their materials. They said, the agencies will get tertiary prevention. So that's for like the crisis intervention, intensive family preservation. And then they say the nations will get the primary and the secondary. So that was in their materials, but that's not what's in the draft FSA. And we're not sure when or how that draft FSA is going to be amended, right? So if they made all these changes and they're going around telling everybody this is what it is, but it's not in the agreement, where do we see it? And do you as BC get a voice when it comes to those amendments, right? Again, Sarah said this, but I'm just gonna beef it up because in Manitoba, we're very litigious. So many things go to court, and I actually have to go back because Wednesday I'm in court arguing on national standards. And it's crazy to me that we have to argue if this is law. Why do we have to go to court and, and prove it each time, right? But it's agencies and First Nations that are providing child and family services are required by C-92, the federal act, to prioritize prevention services over any other service, as long as it's in the child's best interest to do so. So that's a legal obligation for agencies, yet there's no funding. It's a legal obligation for nations, yet there's little to no capacity and not the same level of insurance liability as agencies. So again, that's going to create a gap for children and families. Another aspect that supports this whole thing was because of, a lack of prevention services. Some of the ways we get around it and problem solve, well, we have the IFSD, these experts, right, that came and said, okay, we should be doing this based on outcomes and performance. If we really want to get at the issue of well-being, for children and families, we got to really get smart about how we're tracking it, how we're monitoring it. And so the results funding is being provided at 5% of an agency's annual baseline funding. And this, of course, again, was recommended by the IFSD for First Nation agencies to track outcomes to demonstrate impacts that efforts are having on the well-being of children and families. So it's not just, in Peguis, the ED said this in Manitoba, it's not just, here's some craft dinner and some groceries to get you by, right? What are the root causes of why that family needs that? How are we getting at those root causes, right? The impacts of colonialism and intergenerational trauma from residential schools in the 60s scoop. How are we actually getting at those root causes? Yes, there's this whole, regime that's purportedly set up to try and deal with this, right? So again, there's a lot to get into there, but we need to track how we're doing that. And one thing that's clear to me is that it doesn't matter which government is in power. As First Nations, we're so used to feast and famine, right? Where, okay, if it's the Liberals, they're Conservatives, no matter who's in place, our ability to demonstrate how much we can, change and impact the lives of our children and families with what we get depends on being able to show this results, right? Those outcomes are so important. So now results funding is allocated to First Nations, but data tracking is the responsibility of the agencies. So it's not clear how agencies will meet the requirements for data tracking under this draft FSA. So First Nation agencies are required to track data on knowledge of Indigenous languages, connection and access to land, community-based activities, spirituality, family reunification, placement within the community with family, stability, incidents of abuse while children are in care, the reasons kids are entering care, housing issues, post and prenatal services, medical services, mental health, like that whole list. Agencies have to track that if they have no funding for it. Nations are getting the funding, but not a lot of nations will have the workers and the people in place to know how to do all this stuff, right? Mary and her team have been doing it for years, right? And it may not be an issue, for teams when they're in the same canoe, right? When the nation and the agency are working together, it may not be an issue, but we know that's not the case for a lot of our nations. So it all brings us to just this troubling, there are going to be shortfalls in funding. And I'm thankful to Cindy because she provided us with some projections that IFSD has already made on this. So a breakdown of the expected spending per region, as my colleagues have said, it's not yet available to the parties. Certain key information is missing. But despite this, IFSD did an analysis of expected spending for the first 5 years of the agreement based on available information. They found that there's a significant spending shortfall. that there's a shortfall of 2.379 billion over 5 years in the Manitoba region alone, with Manitoba being the most shortchanged by the agreement. Across all regions, the IFSD projects a 9.874 billion shortfall over the first 5 years of the agreement. So in BC, that shortfall for you is 1.157 billion. So we know there's going to be shortfalls. And again, like I call it soft on discrimination and, you know, whatever you want to call it, right? But it's just like, whew. So we know there's going to be shortfalls. So what do you do when there's shortfalls under this agreement? This agreement says that service providers can file a funding adjustment request. And so this is in sections 191 to 199 of the draft FSA. So under section 191, a First Nations service provider, even though that includes a First Nation, in these provisions, they've distinguished the two. So an agency may bring a funding adjustment request if it is unable, within its current funding, for reasons beyond its reasonable control. And it throws out all these terms that gives it flexibility so they can interpret and do all these things with those words, right? To deliver services required by law, eligible to be funded by the Reforms First Nation CFS program. So agencies can bring a funding adjustment request. First Nations can also bring a funding adjustment request to provide prevention services which are adequate to respond to a prevention need created by an unforeseen event beyond its reasonable control, not including reasonably foreseeable natural events or other circumstances covered by other government programs or policies. So there it is again, setting itself up. You First Nations, you can go when you have funding shortfalls in prevention, right? But it's only, you know, for those unforeseen events beyond your reasonable control. What is reasonable control? That's all left up to Canada and their decision makers and then their tribunal to decide. Section 193, it says requests received on the same events. So again, those situations that happen where, you know, the nation and the agency, we hope, you know, and it does presume a lot of division, right? But it says the nation's requests are going to be prioritized. Completely understand, but it just, the divide is so apparent. Section 194, agency requests must be accompanied by written support by the leadership of the nation. That's fine. So within 50, again, and this is just to show now the gauntlet that you have to go through if you're short on your prevention funding. Within 15 days of receiving a request, ISC shall meet with the First Nation service provider. So ISC has to meet with you. Within 30 days of that meeting, ISC shall, it says, shall make a determination on the request. So shall to me means like, you gotta do it. That's what they tell us in law school, right? Shall and all these terms that you use in legislation. Shall, you gotta do it. But then they say in the very next breath, if ISC has not made such a determination within the 30-day period, the request shall be deemed to have been denied. This is where, again, those feelers of like, okay, they're doing this to First Nations. Do they do that to anybody else? Do they do that to anybody else? Or there's immigration, all these things, right? Do they just, oh, we're not gonna answer you. So just assume that it's no. And go ahead and do all this other stuff. So just wait until you see all the other stuff we gotta do. So then it says, it's deemed to be denied, and the agency can access the claimant dispute tribunal. Then, and again, they don't understand what urgent basis means, because as Dr. Blackstock has pointed out, they're currently in litigation on a non-compliance motion on Jordan's principle, that they have this just voluminous, and pretty much every nation could probably submit evidence on how many Jordan's principle requests have not been complied with, even though they're urgent, right? So we know what they mean when they say urgent, and we know that it doesn't mean the same thing that our children and families experience on the ground, right? So again, even on an urgent basis, ISC shall take all measures to ensure the safety and well-being of the identified children, youth, and families within 5 days. Again, shall. But then in the next breath, if ISC has not made a determination with respect to the request within 10 days of the urgent request, the request shall be deemed to have been denied. And you may access the claimant dispute tribunal. it just, ooh. So now the claimant dispute resolution tribunal, get this, right? So those are, that speaks as well, there's gonna be, you know, enabling legislation for it. We haven't seen it yet, right? We know that there's some key pieces in there. It's made up of the president and the adjudicators. Again, as has been pointed out, the president is appointed by the governor and council on recommendation of the minister of ISK. So the minister of ISK is the one who's gonna consult with AFN, COO, and NAN, and come up with who's gonna be that president. The president then selects a roster of adjudicators and establishes the rules of procedure. Then there's gonna be navigators who are gonna assist in filing a claimant dispute, to help them, you know, do the paperwork and understand the rules. Then there's gonna be duty counsel for independent legal advice to claimants. So the claimant, so if it's an agency, if Mary is short, you know, short in her funding, and she probably is gonna be, she's gonna submit after Canada, maybe they'll respond, they probably won't. So then it's deemed to be denied. So then Mary's gonna go to the claimant and she's gonna file a claimant dispute notice, at least within 90 days of receiving notification from ISK of the action that gives rise to the claimant dispute. And again, that's assuming they take action, because if they don't take action, it's deemed a denial. That claimant notice she has to fill out. So here's Mary TG and her team are gonna have to do a statement of the subject matter issues of the claimant dispute and a summary of the underlying facts and a statement of the remedy sought. Okay, we're just getting there. So Mary's gonna have to now do all this work, right? I mean, it says in there, yes, that this process can't abrogate, it can't take away from the claimant's ability, you know, their rights under the Canadian Human Rights Act. It says that, but then it just offends a whole bunch of procedural fairness like rules, right? So we're gonna get to those. So when the tribunal receives the claimant dispute notice, the president shall recommend to the claimant in writing that they seek independent legal advice from duty counsel. So Mary can call up Scott, you know, get some independent legal advice on this whole thing, right? Or not. So after getting independent legal advice or signing a waiver that you don't need independent legal advice, the claimant provides written confirmation to the president that the claimant consents to proceeding with the claimant dispute and not filing a complaint with the Canadian Human Rights Commission on the substance of the claimant dispute, or bringing the substance of the dispute before court. So you say, okay, we're gonna go through this whole gauntlet. We're gonna give up, you know, our rights, you know, under human rights legislation, and we're not gonna go to court. But it doesn't specify the time frame for doing any of that. This to me was just like, oh gosh, so I'm visualizing how this is gonna work out. Then it says, when the president receives the written confirmation from Mary that, okay, I talked to Scott, I'm gonna waive my rights. I don't think Mary will do that, by the way. I don't think ever, right? But you get that written confirmation. It says, the president promptly delivers the claimant notice to ISK. So here's ISK just making everybody do everything it needs. Get me that claimant dispute order. Get me this. So the president goes running and gives the claimant dispute notice to ISK. ISK shall deliver its response to the claimant dispute notice within 30 days. So there finally, you're getting a response. You're not getting a response when you say there's an urgent crisis, a mental health crisis. We don't have the prevention funding, and ISK doesn't respond, it's denied. But here after the president, you know, after Mary has to summarize the facts, summarize what she needs, get some independent legal advice, surrender all her rights. Then it goes to ISK, carried by the president, promptly to ISK. Then ISK makes the decision, right? Then within 20 days of getting that written confirmation, the president appoints an adjudicator, a sole adjudicator, one person, or a panel to then hear it. Within 20 days after the delivery of Canada's response, then the adjudicator, the panel, convenes a pre-hearing meeting in the hopes of reaching an agreement on procedure and procedural orders. So again, okay, all right, so we're wrapping up here. But that just shows you the gauntlet that, you know, we know there's gonna be shortfalls, and this is the process that nations and agencies are gonna have to go through. There's all these things, right? It's like, there's a cultural officer, but it's employed by Administrative Tribunal Support Service of Canada, right? They have a role to help facilitating in a manner that's just, culturally appropriate, right? They can make interim orders, so it's like they've looked at the Caring Society's submissions, right, on here's what the Caring Society thinks needs to be done, right, to make dispute resolution an equitable process that eliminates jurisdiction. So they kind of pick and choose certain things, but then they go and do this glaring misstep on like equality and fairness. So it says, the adjudicator shall conduct a review of Canada's decision, giving rise to the claimant dispute, considering only the materials that were before Canada's decision maker. So that nice masterful summary of the facts, that nice masterful, remedy that Mary's seeking, right? All that stuff and how it's going to impact Mary and her nation on the ground level, this says it's only the materials that were before Canada's decision maker. And yes, that stuff's there, but sometimes you need to hear it directly right from the people, right? You need to hear that from Mary. And it says, the adjudicators may consider the views of the claimant and any associated First Nations, the legal traditions and protocols of the First Nation, the circumstances of the individual First Nation, the urgency of the funding that is subject to the claimant dispute, and any evidence not before the decision maker that's tendered by the parties that the adjudicator finds relevant and appropriate in the circumstances. May, discretionary. So they basically say you only consider the materials that were before Canada's decision makers. You may consider all this other important stuff, like, the crux of the issue, from the claimant, from the nation, the legal traditions, all of those things, right? So just so backwards. Now moving forward, how do we, that's the gauntlet on just one area, right? I had to selectively pick which area I was going to talk to you about today. Trust me, there were many. So this is just one little piece, right? There's a whole host of other things we could have a whole session on. And in fact, that's what we were required to do. That's what the Chiefs in Assembly directed in the December 22 resolution, which was basically have our technicians at the table. Then, as my colleague says, give options. Give us the options, right? Let's have a wholesome discussion. And they were directed, AFN, that you'd have 160 days to review the draft FSA. And I just want to point out that that was on the understanding that the other aspects of that resolution would be followed, that you would have technicians like the Caring Society at the table. Because we know it would have made a difference if the Caring Society was at the table. This agreement totally would look different, we know that. But the process didn't allow, because every time, the Caring Society is coming forward with positions just completely rejected. Here's what's needed to end discrimination, make sure it doesn't happen. Nope, So 160 days, and that was under the ideal circumstances if we had the technicians at the table. The technicians weren't there in 160 days. I don't know if that's enough. I also don't know when the tribunal says complete reform. To me, this is like a complete overhaul of this draft FSA. When we say things and we look at these little snippets and we pull them all together, it's almost like it's rotten at the core, because you have right from that preamble where Canada says, this is about accountability of agencies to nations, right? No, we were supposed to get together and say it's about accountability on your part to us, to our children and families, right? So had the Caring Society been at the table, definitely would have, that would have been first and foremost, front and center, children and families, right? Now, just to share some of the Caring Society's position, just real quick, right? But it's good stuff. And like, it was outlined, right? They can't, so the Caring Society said, the tribunal has to be able to make systemic orders, right? The dispute resolution process has to be able to make systemic orders to stop discrimination, prevent its recurrence, including the power to grant injunctive relief, meaning like, stop it, like the legal whole thing of like, stop it, stop what you're doing, and they have to follow it, right? To compensate victims, deter willful and reckless discrimination and other costs. They can't do that, right? The Caring Society said this process must be nimble, and you have to make sure that, the dispute that could impact a child, that it's dealt with on an emergency basis as expeditiously as possible. That's not in line with what we just saw in the whole gauntlet that nations and agencies will have to go through. And it says, this allows for procedural stalling. This is what the Caring Society said. Because time is critical in administrative decisions that impact children, if an appeal from a denial is not heard or a decision is not rendered within the established time, it is presumed granted So rather than having the whole thing presumed denied by, like that is saying, right? The Caring Society said in those sorts of situations, presume that, just grant it. It's about First Nations, it's about harms of the worst kind. So the presumption should be to grant it. Totally runs afoul of everything we know, and Jordan's, yeah, so I'll leave it at that. As I said, there's a whole slew of things that we could go through, but that was the work that we were supposed to do when we do in unity, right? And it's just been so like here and there. I'm so proud of the Caring Society for taking a stand and saying, we'll get the agreement the same time as the nations do, because we don't agree with the process that keeps out rights holders. That again is the provisions that have been outlined, right? Settlement privilege and all these things, like I get it, yes, for big commercial disputes, but for matters of such importance to First Nations where it's already been the biggest case before the Canadian Human Rights Tribunal, why can't we talk to each other? That's not how we do things. And that's what happened. And we see the results of it now. So there's some time, and in my view, it's not enough time, but again, in unity, I look forward to further discussions. And again, I know BC is one of those leaders, you're always at the floor. You're always coming up with, resolutions. You speak with such intention, conviction, and passion that that's what moves us forward. So I look forward to seeing your position because I know I always see you on the floor at those assemblies and I'm always very proud. So I have to say, thank you so much for having me.
Great presentation, Jessica, and what a powerhouse. We're so honored to have you as part of our team and people like Jessica. We're gonna get this done right. We're gonna get it done properly. And without further ado, our last panel person, of course, is none other than the phenomenal champion of children, Dr. Cindy Blackstock.
Thank you, Tracy, and thank you, Mary, and all the rest of the folks. I would just want to recognize all the chiefs, all the elders, all the young people in the room, both past and present, who have been part of the struggle. And I also just want to take a moment to recognize Grand Chief Kathy Marin from the Assembly of Manitoba Chiefs, who so tragically died unexpectedly and who held children and young people so close to her heart. I have a presentation with some material in it, but I'm not going to do it because these colleagues have covered a lot of the reasons why this agreement is so fundamentally flawed and ought not be supported, nor will the Caring Society support it if it goes before the tribunal. We will actively oppose this agreement. I need to be clear about that and transparent to you about that. The reason that we left the process, it was to file the non-compliance order motion on Jordan's principle. Because you see, we had negotiated in the agreement in principle a whole work plan for Canada to stop the discrimination. And Canada breached it immediately. That's important to know. Because they want you to keep your fingers crossed and trust them with this agreement. That agreement in principle included the work plan to address the non-compliance with Jordan's principle, but it also required confidentiality, and it required that no party who is a part of the agreement in principle could ever go to the tribunal and get relief. Now, the way that I have always approached this case is that this is about your kids. This is not a time for closed negotiations. This is a time for open and inclusive negotiations. And in fact, we know it works because that's how we got the orders. We would go to the chiefs to get direction on key points. We included technical experts all over the country. Some people think that's unwieldy. I think it's the only way we can go. I want to just cover a couple points and highlight some things that colleagues have said. The first thing that I think leadership needs to be critically aware of is this agreement isn't the end, it's a precedent for what's to come next. on Jordan's principle. And let me read, actually, I'm gonna be leaving early like Jessica. The reason I have to leave, you'll see me bolting out of here at about 10:30, 11 o'clock tomorrow morning, is because we have the non-compliance hearings against Canada on Jordan's principle Tuesday, Wednesday, and Thursday, so I have to fly back to Ottawa. And you remember the graphic, that beautiful painting that Jessica showed about how things can be co-opted. I'm just gonna be really honest with you, and I'm gonna read the Assembly of First Nations submission on Jordan's principle non-compliance. This is paragraph 79, it's their conclusion. Save for the interim relief requested below, the AFN confirms that it takes exception to the substantive requests for relief raised by the Caring Society and endorsed by the First Nations Leadership Council, particularly as it runs contrary to the existing mandates of First Nations in Assembly and by Canada mandate. It's not evidence-based and does not reflect the negotiated pathway that has been mandated by the First Nations in Assembly, which is also consistently being called for by the courts as an act of reconciliation. The last words of their submission are that all final relief sought by Canada and the Caring Society and supported by the First Nations Leadership Council ought to be dismissed. So the Assembly of First Nations is prepared to litigate against other regional bodies and will be doing so on Tuesday. I want to recognize and thank the First Nations Leadership Council for coming in. They don't agree 100% with all of our positions, but they are thoughtful and considered recommendations and orders that the Leadership Council is seeking. The AFN, in its legal submissions and also with Canada, they say that they want to bring, they want short-term orders. And the reason for that is that they anticipate negotiating a final settlement agreement with Canada, AFN, Kuanan, and that will be complete and I guess endorsed and in effect by April 1st of 2025. So that's important for you to know. If you think this is a good process, this is a good news story for you because it's going to happen again. It might already be happening on Jordan's principle. And if it happens on these two things, then imagine what else Canada can achieve. It's interested in reforming health, education, all these things that are on the expense side of the balance sheet for the government of Canada. It is interested in both self-government and in being able to enshrine in these collective agreements. There is no process to amend the agreement. None. Because it presumed that you would rubber stamp it. You would see the $47 billion and you would sign up for it and you would do it and you wouldn't do your due diligence and you would go for it. Because the reality is on the ground that we're underfunded in just about every area and every dollar is desperately needed to meet your community need. But like most good deals like that, it's too good to be true when you read the actual text. And that's why it's so critical that First Nations leadership and their experts in their communities are supported to be able to do this review. Currently, the only groups that are receiving money reimbursement for their legal counsel are the parties by Canada to sell the deal to you. There ought to be an independent field of funds that allow you to do your due diligence with the people you trust and have authorized in your particular nation. Sarah talked about the prevention funding. And this, and Jessica and Mary also talked about this animosity that's created, right? The problem is not Canada. There are friends coming to the table with $47 billion. The problem there, these agencies. Well, I've been around at a national level only since 1997, and I say it with that way because there's so many people who were part of the struggle before I got there, and I want to honor them. But I was there the day the resolution passed in Chiefs of Assembly to give authority to the complaint. And what does it say? The chiefs recognize the dramatic underfunding of their agencies, which is not allowing them to be able to support families. That was the original mandate by the chiefs for the filing of the complaint. Now, Canada, what they're doing is they're taking one pot that was considered okay for agencies and they're splitting it with First Nations. They're not providing capacity building for First Nations. And what they could have done and what they ought to have done is advocate for additional funds for First Nations with capacity building. But they did not do that. They also are, importantly, when you're thinking about this, they are going for not only ending the tribunal's jurisdiction, but getting rid of all the orders that are backstopping you right now. Those will all disappear when they get this final settlement agreement approved by the tribunal. All of them. You will not have the tribunal's orders in the backstop. I understand why First Nations want a First Nations controlled judiciary. I get that. But that can't mean that we get less than what the mainstream can provide. Because honestly, if that's what it is, I don't want it. And they have $100 million booked in this agreement or for that alternative dispute resolution mechanism. Frankly, if it's as weak as it is right now, I say scrap the whole thing and give the money over to First Nations and agencies to deal with the opioids crisis. That would make a bigger difference, right? So what are we gonna do now? I'm gonna go right to that slide. And here's my disclosure and everything else, and you'll see all this stuff. So, I want to kind of focus on the fact that you do not even have a complete agreement. I mean, that's a lack of respect for leadership. These are big pieces that are missing. So there's an appendix 10. Now it's right in the back and you know, you're gonna look at that, but that's the way the money flows and to who it flows on under what conditions it flows. And, you know, I want to thank, I know Judy's here to say all the other leaders at the Assembly who were so helpful with us in kind of educating people and bringing forward those resolutions. That, by the way, often got blocked by AFM. There are serious resolutions that ought to have guided both the non-compliance motion on Jordan's principle and the final settlement agreement, and they were blocked. The chiefs never even saw those resolutions. If you look at what the current proposed meeting for October 16th to the 18th, there were resolutions submitted for that. They're not listed on the website again. Because really, in my view, the only resolution in play is say yes. The sections 42 and 40 in 42, they were supposed to be done by September 1st, as you heard. I followed up with the department. And they say they might be done in the next 2 weeks. That would leave you, what, 2 weeks to look at them? When it comes to this enabling legislation for the alternative dispute resolution mechanism, that's not coming until after the tribunal agrees with the agreement. And all the appeals have run out. So leadership is gonna say yes to this alternative dispute resolution mechanism, and you don't even know what the legislation looks like that's gonna form that thing. A French version, I wanna really honor the French, the First Nations that were colonized in French. It's not their fault they were colonized in French, but they've only got a version as of August 14th, and it's a very deficient translation. So as difficult as it is for you, it's even more difficult for them. So you need a complete agreement to make any decision, right? You can't have one with all these big holes. One of the things I hear is Pierre Poilievre is on the horizon like a dark cloud. Well, I've seen lots of dark clouds, and let me tell you, this government's been no joy to deal with either. We've had 25 non-compliance orders against them. Some people say we have to get a deal, and I think that honestly, I think that was motivating that table. They were focused on getting a deal, and they got a deal. But it's not the right deal for children. The thing, and that is really the risk, right? You rush this process through, and then you end up with a bad deal that can be undone by polyam like that. And honestly, I can just tell you, I'm not a lawyer, and I have colleagues in this room who are just so brilliant, but I will tell you my best bet is that he could undo it like that. There's not sufficient safeguards to protect against government changes in the final settlement agreement itself. And the legal orders of the tribunal, for all their flaws, we can at least enforce those, right? And the best safeguards, what I would like to have seen in this deal is statutory funding. Right? For Jordan's Principle, CFS, and probably a lot of other mandatory First Nations programs. We need a clear funding purpose. We need the funding structure, because you can't get Canada to be ordered to spend more money, but if they don't follow a structure and it leads to discrimination, they will be ordered to fix that, which always means more money. And showing results for kids. Here's the big thing. Buy now, it's like Canada's like the shopping channel. Buy now or you get nothing. There's only 2 or 3 of these things left. And if you buy now, I'll throw in an extra set of knives known as the housing money. Well, the housing money was announced in the agreement in principle. We're already 3 years into the 5-year deal, and you'll see it actually ends in 2 years. So that's what you would be buying. That's what you would get in trade for what you would be giving up. So I cannot, in good faith, recommend that you take this. So here's the existing orders, and all these PowerPoints will be available to you, so you can do your due diligence. You can fact check me too, and I really encourage you to do it. Here's our big list of concerns about this deal. And one of the pieces that I just want to underscore is the small populations in BC, but not just in BC. What the heck are you supposed to do on prevention for $75,000? We actually at the Caring Society, when we got some feedback, as you notice our positions, we've put them out there publicly, we put all our amendments out there publicly, and we get good ideas back and critiques. And one of the critiques from our chief in BC was, what are you doing to make sure it doesn't disadvantage small populations? And I thought, not enough. He's right. So we're using our own money at the Caring Society to fund a study to look at that. And I also just want to say, we aren't funded by Canada, right? So I'm hoping you all buy memberships, because I think there's some value in us doing this. We're not going to support this agreement, but here's the real truth. I'm going to go in front of the tribunal and I'm going to point out why this thing is not a good deal. But if the chiefs have supported it, I'm done, I think. I think that it'll be very hard to overcome that. The tribunal has great respect for free, prior, and informed consent. It has great respect for First Nations and making that decision. And it talks about that time and time and time in the decisions. So if your decision is yes, and I go up there to Cindy Blackstock and Spirit Bear and this fabulous board, and I say no, I think the reality is it's going to go through. What would work is if you say no now. And not no a little bit, no. And then you have to recalibrate how that table looks. Because when we filed the non-compliance motion, we were invited back, but under the same conditions of the agreement in principle that resulted in the breach for Jordan's Principle. And it was clear to us that it would be a 4-to-1 vote on these provisions. If this is going to be renegotiated, or if leadership is interested in seeing a final settlement agreement on Jordan's Principle, that table needs to be revised. Here's what I would like to see. I'd like to see a new negotiation mandate, protocol, and team approved by the chiefs. I would resist the temptation of saying that this whole thing can be fixed if you had a BC representative on that reform implementation committee. Because remember, like, think about it, if it was any of you, you could talk to anybody else in this room. Well, that's not representation. The whole agreement governance is consistently flawed. We would rather see as a governance structure that chiefs retain the decision making. There's an advisory children's chiefs committee that provides advice to the chiefs and brings things to different decision making bodies. And then we have the National Advisory Committee. That gets rid of the 7 committees that are proposed in this final settlement agreement. And by the way, with the NAC, we're all volunteers, and all that money can go back to kids, right? This meeting coming up, I don't think is ready for a decision on approval because the agreement is not done. And also, I just want to respect the fact that many nations were dealing with emergencies. I just want to honor the Coden and the landslide, and many of you were dealing with wildfires, suicide emergencies, other types of things. So some leaders are just coming to understand this agreement. I've been sitting on this, living and breathing it since July 11th. But others are just starting to get an opportunity to look at it. That is not enough time to make a decision to vote it up or down. I would like you to vote no, that's clear. But you have to make your own best decision for your kids and feel comfortable that you have the information to do that. What I would suggest that meeting be used for is to talk about revisions to it, or quite frankly, I think the quickest path to success is to rewrite it. I think there's so many fundamental flaws peppered throughout it. You've got a sense of some of them here. I think it's like when you get somebody really bad at something that's really bad, trying to fix it. Like if you've got a car that's, been out there in the garage and rusting out for all those years, yeah, you can put a new shiny bumper on it, but it's still not going anywhere. Sometimes it's easier to just cash in your chips and head down there and get a new used car that can get you from A to B. That's what I think we're dealing with here. And then have a vote maybe in December, but we have to be cautious against the weaponization of time. Because that has consistently been the thing, right? Canada weaponizes time at the negotiating table, and they'll say, we need to approve it now. Now, I'm not a politician, so I don't have to think about all the changes in government as much as all of you do. And I know that those are legitimate and real factors. But I do know this is what you get if you rush it. This is what you get if you leave out First Nations experts. And by the way, this is what you get when you leave out First Nations leadership. It's this kind of agreement. And our kids deserve really much better. Here's the pieces around what I see as being the key roles that leadership has to, and I can't underestimate this. It is critical that leadership make an informed decision on this agreement. And I'd like you to stop AFN from negotiating the Jordan's Principle FSA, or else we're going to be back here on that one. And I just want to recognize Jordan River Anderson and the Anderson family. They have entrusted all of us with Jordan's sacred memory. So when it comes to Jordan's Principle, it is sacred. It's ceremony. It can't go into a space where children are missing from it. That's why Spirit Bear is here. He's here to remind us all about who this is all about. This is not about First Nations getting money. This isn't about agencies getting money. This is about children getting money. And having to be able to hold the hand of the person who can best deliver that service at that time. And yeah, that might change over time. But right now, that child needs a hand to hold. We can't have these political kind of debates about this kind of stuff. It's far too important. And I'd like to see it inclusive and national in scope. We've got a bunch of amendments. We've outlined them here. And we welcome all of you having feedback. We've circulated them broadly to all of the First Nations technicians, and what we have an informal working group. And those of you who are technicians, you can join us. It's an ever expanding circle where we talk about stuff like this across regions. But those amendments really, that's a key decision for leadership. Do you think this thing's worth amending, or do you think it should start off and we should just, and it's not starting from scratch. We got a lot of good stuff. We could each take a hunk as experts, come back with a draft that would be far stronger and better for our kids, and something that we could feel proud leaving to them. Because right now, it would break my heart if this was the end. Because in a year from now, I think it truly will be the end. Because there's so much power for Canada. So I thank you for this opportunity.
Thank you so much. I'm looking at the time, and I know we're over time, but it's such an important topic, and I really wanted to make sure that as much as we could, you know, we have we're deliberate in who the panel is going to be, so you can really understand, to see what we're dealing with. I'm gonna entertain the floor if there's a couple of questions, and then I'll wrap up with some closing comments, and I'll try to have you out of here within about 20 minutes, half an hour. Yeah. Got the mic? Oh, yeah.
Hello, everyone. Good to be Helen Henderson, West West, and I'm happy to be here and connecting with all of you today on such an important topic. Something that is innate in all of us. We live and breathe it every single day. Thanks, Joe, for the presentations. I am a former child in care, both provincially and federally, since birth, actually. So I've lived in all of these worlds. I've been grouping now for 5.5 years. I've held this portfolio on the treaty. I know what jurisdiction means to me as a Jesken. And I'd be remiss if I didn't speak and feel like I'm being herded, and I've used that term before for sure in all of these other jurisdictional fields that have been mentioned. And it's very strategic. You may have heard me say that as well. That we're being herded in all of these jurisdictional fields. But what's apparent, what's very clear to me, and I ask things in a very simple way, for my very simple understanding. Is this agreement good enough for me? And if it's not, what needs to go in the agreement? And I've listened to the presentation, and I've heard some very upsetting things. And as Googby of PFN, Jesken First Nation, you know, we're very busy in our daily lives, and we've been through some worldly trauma together, and we're all coming out, seeing the world in a different way. But work has been happening along the way, seemingly without free, prior, and informed consent. And as Googby, I have to step forward and say, where did I miss this? How did I miss this at this point at 11th hour when we're expected to go and vote somewhere? But I always ask, who are the true title and rights holders for TFN? Who makes decisions for us at TFN, and how does it impact our children on the ground? And we're not even talking about all of them even. We're only talking about on reserve, and that hurts my pussman. It really does. And if we're talking prevention, I said this to our delegation last week when we were talking about these issues. We're missing generations and generations of families here since prevention has been on the table for discussion. And then never mind the province of BC, who only started receiving it in 2018. Our members have been living away from home for how many years since contact, because there's not the resources in community for our members to stay home. So they left, and they're out there, but they're unaccounted for in prevention. They don't get prevention. If they're not attached to a delegated agency or MCFD, if they don't come into care, they don't receive services to prevent them from coming into care since prevention has been talked about. And that hurts my heart. Moving down these pathways, we'll be expected to carry on that discriminatory practice ourselves. There's still a gap right now. Because ever since the creation of the Indian Department and how they were deciding to look after us, they transferred that through Section 88 to the province. They have fiduciary responsibility to all of our members, yet we have lost generations out there unaccounted for in all of these numbers. Absolutely 47 billion isn't enough, absolutely. Because we have unaccounted lost generations of our Genomic wood consultant out there. And that breaks my heart. It breaks my heart, but it gives me the resolve. It gives me the fight that we all need to do for our children, our families, our youth. The province of BC needs a voice, and talking to my colleagues, like, how did these conversations happen? And I'm not going to play that ignorance game, because I have a responsibility, and I hold up all the work of all those that went before me to get to this point. There's lots of absolute good work, but if it doesn't land in your community the way you need to, and if you're going to run out of money in 10 years, and there's no enforcement, and Canada gets to walk away, they're already doing it through Jordan's principle. And what, in my very simple way of understanding this very complicated process that they put in front of us, is that if we weren't negotiating jurisdiction over here, headed down this pathway, they'd have to do this anyway. And what's the cost today? What's the cost today in comparison to what's being offered today? It has to be more, it has to be enhanced, and those numbers aren't enhanced numbers. And if we're asked to achieve true self-government and self-determination, and our hands are tied behind us, and we're blocked from our territories and the resources that could help and assist. When we're talking 47 billion and we can't even invest that in perpetuity, because it's just a number floating. It's not actual money in the bank. So time and time again, we're not set up for success. And I came looking for some recommendations, because I'm somebody that's certainly passionate, but my eye has been in community because our people are dying. That's my truth. TFN has lost another member. I just got word today that we lost another young member to cancer. And we've had a consistent death for the last 15 to 24 months, losing one member every month. So we have to get this right. The whole reason why we're in this process is to save our members. And the heavy language on Canada's part is unacceptable. And for me as a Gookbeat, I do want to apologize, because my site was elsewhere, and it needs to be here. And I'm here, I'm present 100%, and I'm ready to roll up my sleeves and do the work for our children, youth, and families. So I'm very clear on process. I've seen the concerns, I've seen the recommendations. I want to know what BC, what's the mechanism for this group to make a decision? Is it here? Is it AFN? Is it BCAFN? Is it Summit? You know what I mean? There's so many jurisdictional decision-making type structures. But at the end of the day, I'm Chkeskan First Nation, and that's where my title and rights sit. And when I find out that there's conversations happening without me in the room, that's a problem for me. And if they haven't met free, prior, and informed consent, if we haven't even met it because we're bound to confidentiality, if we can't bring this in front of our members and share the realities, the impacts, the true impacts of what this really means, we haven't met FPEC and it's going to be challenged. We'll be doing that to our own people. So in a very simple way, what's the next step for all of us here that are now receiving possibly, you know, this pertinent information at the 11th hour, playing catch up? I'm trying to wrap my mind around, you know, what was presented in terms of, you know, why Caring Society is no longer part of the parties. And I'm somebody that mitigates, you know. Did we not expect 50 million? And if we reach this point and they offer 50 million, what's our next? And what's our recourse then? I'm somebody that likes to go down every avenue and mitigate what that looks like. So that's my question in a very simple way is what's our mechanism to ensure that the nations in the province of British Columbia are heard? Question.
I think that's all of us, you know, sort of on blindsided on July 11th, that the draft agreement is sent to or given to us on that day, and not even having the dignity or the respect for chiefs, hereditary chiefs to provide us before the media in Canada got it. And I think that's why, you know, having this important discussion today, understanding that actually October 8th to the 10th is the BCAFN, there's a resolution process there. But I do believe that just to have the discussion and to be very clear as to why the Caring Society, we don't support this, the agreement the way it is. But the reason that we're not at the table, that we had been at the table, that you have to remember that. And as I said, while Canada was sitting there reneging on their, you know, commitments and not, you know, and the way the work plan wasn't even upheld by Canada when it came to Jordan's Principle, we in good conscience could not sit there anymore. And as part of the agreement and the agreement in principle, it required that no party could go to the CHRT again. And that's why we're not there. And so when this agreement happened, we weren't there to say, you know, you can't do this, you shouldn't do this, it's not, we weren't there. So that's why we're saying the way it is presented, we got presented the final settlement agreement, this draft, the same time everybody else did. And so when we reviewed it within the next couple of days, it just got worse and worse and worse to the point where I'm gonna say it's just, there's no way in good conscience, me as a hereditary chief, the ultimate rights holder, would I be able to support that? And so I think the next step really is to come up with some solutions about how are we gonna do this in BC? We're BC strong, we have, you know, over 200 chiefs. And so what are we gonna do? And I think we have to be very clear, there has to be resolutions that, you know, cities talked about this, that there needs to be a refresh, a restart. A lot of the work has already been done. Like there has been BC, you know, recommendations and the voice has been there, you know, through the NAC, I represent BC in the NAC, but through the frontline workers, through the studies, through the surveys with IFSD, all of these, that work has already been there. It just hasn't been implemented into this agreement. So I think a resolution that would state that, you know, that there needs to be, as Cindy said, a new mandate that sets out, that gives direction to say we need a new negotiations process protocol and a new negotiations team. We can't keep flogging a dead horse here. And I think when we look at this, and just to give you a little bit of backstory, one of the things when we came in the negotiations table for long-term reform, what is negotiations 101? Is that you have a negotiations protocol and you have a process to ensure that the subject matter experts, the importance of that, the evidence-based research is considered in the agreement. So we did a beautiful little schematic, a beautiful negotiations protocol to say, this is how we're gonna proceed. This is how we're gonna get decisions made. This is how you're gonna get direction. This is how we're gonna get direction from our chiefs. That was not supported. In fact, Canada at one point supported it, but AFN Legal didn't. That's how ridiculous it was. So here we have going through negotiations, the most important negotiations we'll probably ever see in our life. We will never see a bigger agreement than this in our lifetime, ever. And yet, we don't even have a negotiations protocol, no rules of engagement. So I think even that, so when we're asking for that, I think that's a reasonable piece. The other negotiations 101, you never, ever, ever accept the first offer. Like, we do not accept $5.2 billion compensation. But what the heck is this? Who in their right mind would sign off on that? So when we see the signatures, same people trying to sell us this agreement. So we go from 5 billion to 20 billion. And remember that. The Caring Society City, we disagreed. We would not take 20 billion because it was leaving out some of the ones that should have been compensated. So we said, no, it was brutal. I know Cindy got personally attacked. I know I got personally attacked. It was not a nice time for us, but we stood strong because we're doing it for our children. So then we ended up with, almost 24 billion in compensation. So this 47 billion projection, that's their first offer. We're not gonna accept that because it doesn't do what it's meant to do, and that's to end discrimination, not only now, but in the future. So I think that's what we need to do, is really be very strategic into what resolutions we're gonna have for BC and have their unique, that's what, this is why as much information that we can give you. What I'm gonna challenge the chiefs in this room to do is, that old commercial, you tell two friends and I'll tell, they tell two friends and they tell two friends, and information is power. That's what we have. So I'm going to really request the chiefs that you tell two chiefs, be it hereditary chiefs, elected chiefs, and say, look at this agreement. And get that message out, because there's too many things that does not meet the needs of BC children and families. And so I think then when we're ready, we have to have one united voice. We have to, and it's too important not to come in strong. And I think those are some of the things. We also have to look at as the next step is to become an interested party. Nations can become an interested party. The agencies, the nation. That's why the Chiefs of Ontario have so much power, because they're an interested party. They were parties to this, same as NAB. And so we need to have that same clout. We need to get take our power back here. And I think one of the things, again, I have to say this, and I hear it, we're gonna lose all the money. Remember that in the agreement, this agreement is subject to annual parliamentary appropriation. That means every year, it's gonna go up. Polyev, your government gets in. I've met Polyev, but I don't know if he's really human, but he's kind of scary. What do you think he's gonna do? You know his track record. You've heard what he said. You think he's gonna be honoring this agreement? So the only protection we have, don't forget this, it's a law in Canada. A sitting government cannot tie the hands of the preceding government. So Liberals cannot sign a deal for the Conservatives. The only protection we have is that the Canadian Human Rights Tribunal orders extend to again and again, year after year, regardless of what parties, and they have to follow it. So the Polyev have to follow what is now the existing orders. So to think about that, and those are the things that you need to tell your two chiefs. I'm challenging you. Let them know, don't worry about it. This is a shit deal. I mean, I'm tired. I'm tired, and I'm really, really tired. And I think when Cindy said, after this, like, we're done. Like, if it goes through, like, it's too much. What the Caring Society, like we've always said, and we will always maintain, that we need to have an agreement that's a yes and agreement. It's not whether the agencies get the money and then, or the First Nations get the prevention money. It's like everybody gets the money. Yes, the agencies get the money and the First Nations get the money, because look at how many hundreds of years of atrocities that we have to try and remedy ourselves. We see it in the opioid crisis. It's gonna take a lot of money and a lot of our joint minds together to deal with this issue. So it's a yes and if ever in history we needed to be united, it's now. And so I think that's that yes and approach. You tell your two chiefs that. Yes, and what we are supporting is this is a drop in the bucket. Let's build on what we've already won, the Canadian Human Rights Tribunal orders. That's about already right now as we sit, it's about 45 billion that we're gonna get anyways. Yeah, so we're gonna get that anyways, under the orders. We're gonna build on that. So not only agencies, but nations as well get prevention dollars, and we work together as one. That's what we need to do in BC, a unique BC approach. So that's what we're asking. Saying, very clear, we're not supporting this deal of the Caring Society.
The other thing I'd just say is, we've circulated all our amendments for your feedback. They're gonna be in your packages. Welcome your additions, especially your feedback on honor of the crown. We want to insert a definition on honor of the crown. And to your point, I just want to really recognize that you talked about on and off reserve. One of the huge wins for Jordan's principle was the definition of a First Nations child as a child recognized by their nation on or off reserve.
Yeah.
That was the definition the Caring Society was promoting in this child and family service definition, and we'll need a lot of support from the chiefs to try and shift Canada off its current position, because if I'm Canada, I have to give them credit. They did an excellent job negotiating. This is a start the car deal with Canada.
Okay, so just, I'll take another question, and I know it's late, and I feel like I've been rambling, but I'll get another question, and thank you for the question, your thoughtful insight, Chief Helen.
Yeah, I'll be quick and I won't stand up because I'm old and it takes me too long. I just have questions I'm gonna throw out, you don't have to answer them, but this is something to think about. Where is the data the government uses to make these arbitrary decisions? Question one. Another one is, this is to Scott. In one of the non-compliant issues, the word should came up. I don't know if it was for us or for the government, but if we use words like should to the government, it gives them an out. Instead of should, they will comply. And I'm sorry, I'm gonna be using colorful language, but we can't put up with their bullshit any longer. The other thing is, most institutions across Canada are working towards decolonizing. What in the hell is the matter with the government? Do they have any brains out there? There's this saying that I keep hearing is arrogance, which they are, is the anesthesia that deadens the pain of stupidity. There must be a lot of that going on in the bureaucracies in Canada. And one last thing, capital funds. Where's the sources for the capital funds? Does anybody ever think about the extraction of our natural resources from our homelands, whether they be treaty, whatever? What happens to those taxes? Do they come back to us? I bet your bottom dollar they don't. And yet the white people out there complain, oh, you're using our tax money. Bull, feces. I'll try to be nice. And the last thing, what the heck is reconciliation about if this kind of nonsense is going on? I'm getting old, I'm tired, and I'm fed up with their stupidity. But what I also want to know is what kind of holy hell can we create if they continue in this colonial way? Thank you.
What I would say is that, and I want leadership to feel like this is the good news out of this whole mess. It was extraordinary, just as this room is, you're all here on a Sunday because you love your kids. One of the things that I was really worried about when I read it on July 11th is I knew people like me and everybody on this table would be reading it, and some of your directors would be reading it. I had no idea how much leadership would be canceling their family vacations, would be relying on the experts in their regions, would be spending their own nation money to get their own legal analysis. And I have to say, although there are some supporters for the agreement, in general, those are people who have not read it. What I find across the country is there are people with serious questions about this, including in Ontario. And so I think this is a real opportunity to create some national unity around this. Because this is about every kid. I want the kids in Ontario to do really, really well. And I want the kids here to do really, really well. We need to create a national floor below which no one sits, and then regional and nation level variations that go upward from that. That's what we need to accomplish, and we can do it. But we have to stand all together. We don't want the divide and conquer to be amongst the regions either.
Thanks, Cindy. You have a question? There's one more question, and then we'll take a question, then just have the closing and kind of wrap up with the next steps.
Yeah.
Yeah.
So I'll just read the question that came in from online, and then Linda, feel free to unmute if you have anything to add. But she's asked, what is the timeline for a vote, and what are the numbers needed to pass from all of each province?
So it's not one of the things I should have clarified is that the Anishinaabe Nation is holding a vote. I think it might be as soon as this week. The Chiefs of Ontario will hold their own vote in advance of the national vote. But they have not scheduled a date for that yet, given that the thing was deferred from September. So that's an opportunity for you to think about too, is whether you want to vote on it before it even gets there. That might be an opportunity for education, for leadership and technicians who are not at this gathering, but have not had the opportunity to review it. So that's important to know. The current idea is that it's supposed to be voted on the 16th to the 18th in Calgary. That is, and then within 30 days of that, they would bring a motion to have this whole thing approved at the tribunal and have the final settlement agreement replace the tribunal's orders and the tribunal to cease its jurisdiction. So that's the current track that we're on. Now it'd be up to the leadership to say that they want another track. And I think it's definitely possible. And I think the people across the country are looking for regions to come together. And one of the things I would consider is a national chiefs meeting without any, with just their technicians in there and actually talk to other people in other regions. Because honestly, I'm hearing many of the same concerns you have. They're shared across all the other regions. And so I think there's a real opportunity to do that.
Okay.
Can I just ask a follow-up question on that?
Yeah.
I just I'm quite alarmed. Thank you everyone for the presentation. I'm calling in from the traditional territory of the Gitxaala Nation, and I've followed this a bit. I have not honestly seen the agreement. I'm interested to see all the summaries, the legal summaries and legal briefings. That would be very helpful. But also a question I have is, how are the provinces communicating? I heard the kind of the I guess the confidentiality part, but how are the provinces communicating? You know, like this is for all the children of Canada. You know, I'm quite concerned. You know, I want to see how this is going to evolve, but how do we communicate? And I can definitely, I'm looking forward to being a voice of reason, provided I get those legal briefings as well. Thank you.
One of the things that in the final settlement agreement is Canada is really inserting itself into its First Nations governance. So like if your agencies don't follow a work plans approved by the nation, Canada can take any and all action against the agency to bring them into compliance. But there's no provisions for provinces.
Mm-hmm.
The provinces don't have to submit a work plan like First Nations do for their prevention. They don't have to do anything. There's no accountability for them, even when they're receiving funds from the federal side. On this question of honor off reserve, if we change that definition, if the chiefs agree across the country that the definition for Jordan's principle ought to be applied in child and family. This isn't the same legal case, and I want to be honest, like we're not going to get everything that every child needs out of this case. It's got parameters. It's got to be about child and family and Jordan's principle. But if the leadership says that definition of Jordan's principle ought to be applied to CFS, I think we could litigate that well in front of the tribunal. I don't know if we would get it, but I think we have a fighting chance because they've already ruled in that way with Jordan's principle, right? And that would knock the provinces out of the picture in a lot of ways. Right now, what Canada is doing is having bilats with the provinces. And they're also striking these deals, and one of the things we've raised is a lot of First Nations in British Columbia do not have agencies, or some have partially delegated agencies. But you're not sitting at those negotiating tables where Canada is negotiating the funding arrangement with the province of British Columbia, and you ought to be.
Yep.
Because what they decide there will have big implications for your kids and families. So those are a few words about the provinces.
Thanks, Cindy. I think, the key thing here is that we do have support from the First Nations Leadership Council. I'm talking about when we're talking about the Directors Forum, to take any, legal action to end that discrimination between off and on in the interim. So we're definitely, Chief Holland, we are looking at that. We've been trying to work on that for a few years now. I just really wanted to, thinking about everything that's been said and all the stuff that we need to do, that the Canadian Human Rights Tribunal jurisdiction is one of the most important parts. And what we had recommended, what Cindy had always said is, why don't we, like, whatever agreement we come out with, like, the basic thing is that we would have the Canadian Human Rights Tribunal oversee it for at least 5 years to ensure the proper and full implementation, to put them on probation. Probationary period. That's what we're asking for. We're not asking for it to be forever. But the only tool, the only legal instrument we've ever had to hold Canada to account has been the CHRT, because they haven't done it willingly. Why do we think after like April 1st, when this agreement takes effect or whatever, why do we think that they're gonna act any differently? So we have to consider that. And again, you're gonna tell your two chiefs that. I think the other thing too, the spirit of the agreement, for us, the preamble, you'll see it. Our preamble is about, honoring the ones that are no longer here, the victims of residential school, the ones that suffered the 60s school, honoring the children. That's our preamble. Keeping Canada to account to ensure discrimination, not having the agreement is about accountability from the agencies to First Nations, as if Canada, we're doing a great job. Jessica brought that up, a really good point. So we have to think about that. Where is accountability for Canada? When does Canada actually say, we're sorry about the discrimination? We don't, and again, that's another thing. The apology that's got to come from Canada has to come only after an agreement that reflects that discrimination won't happen again down the road. That's when you get the apology. Now it's just nothing. It means nothing before we even have an agreement. So I think the next step, we do have a webinar on September 19th that's going to be co-hosted by the First Nations Caring Society. Again, that's on September 19th, that we can do better. And so we'll go through this agreement. We'll have more time for questions and answers. So definitely we'll have that, and hopefully, again, you tell your two chiefs that. So there's a long list that you're telling your two chiefs, sorry. I'm getting you to do our job. But the other thing to consider, the interested party status. Again, Cindy and then the team of the Caring Society did a really nice one pager, what does it take to become an interested party, the process, how do you do that? So look it up, and again, that I am a witness, we have those 1-page information sheets to go there. But I really think we have to start drafting some resolutions in preparation for BC to have that united strategic approach. And I think that some of the technicians that we have from the First Nations Leadership Council and our Children Our Way Secretary, what we can do is draft some of those resolutions and provide it to all of you for input. We'll also have our Children Our Way Secretariat provide you again with all the meeting packages, the link to the actual the FSA. So we'll commit to doing all of that. And I think with that, again, really the important part is that we want a yes and approach to this. We don't need to pit agencies, because if this agreement is supported, remember what Sarah Clark has opened up with, is that we are going to be in the same situation that we were in that caused us to take Canada to court, where the agencies were not receiving prevention funding. That's why we took them to court. And now this agreement is proposing we do that again. That's ridiculous. So again, think about that yes and approach. And with that, I would just really like to thank our Children Our Way Secretariat, the Caring Society staff, all of you for taking the time to share your heart and your spirit, and you know how important this is. You've taken the time away from your Sunday or, your family and time that you could have been there. We so much appreciate it. And thank you to the wonderful panel, and all the work that the panel's done to prepare for this. I just really, I'm humbled to be here with you today. And I'm just, I'm really optimistic. I know we've had a lot of hard truths today, but I'm optimistic that we're gonna do the right thing. Because at the end of the day, our ancestors are watching us. And we are the ancestors of those not yet born, and we better make the right decision. So thank you so much. Thank you. Okay, we'll have, somebody to do the closing prayer. Deb, Judy? I'll ask Deb and Judy to come up. They're our beautiful matriarch advisors. And here. I just wanted to give a special shout out to our president, the Haida, our chief over there, Jay, and we had Chief Billy that was here, and I really think it's important that, I'm so glad that you're here, because especially with the rising tides agreement, and again, what a wonderful agreement. We go from a high of having the Haida be recognized as rightful owners of their territory to this agreement. So it's one of the things you never know what's up and down. So thank you. Jay.
Quick shaman, thank you for everyone staying an hour later to be able to hear these key and critical discussions towards our children and our families. And thank you for the panels reminding us, especially with Cindy and Mary, where this all started from. So we want to keep the children and the beautiful grandchief told us about, our children, our grandchildren, our great-grandchildren in our hearts, and the ones yet to come. So I'll do a prayer, and then usually Deb does a card, but she can reflect maybe a little bit after. Okay, Kuksham, Creator, we thank you, Creator, for the beautiful people that are here today and online that have come together to talk about the children and the families and our improved way of life, and how much a lot of it's tied to our teachings, both the ancestral teachings, our teachings from our origins, our creation, and also that we are partly connected to each other. We're relatives, and that's where a lot of the wording comes to each other. There was a reminder from one of the elders, even our guests from New Zealand and Australia, we're all related. So that teaching is so important, especially in this conversation, Creator, and thank you for all those beautiful reminders. We're connected to Mother Earth, we're connected to all of creation, and especially the water, which is the source of life. So I thank you for all the ways of being and knowing that when we are collectively together, that comes to the forefront for our beautiful matriarchs, voicing that today in such a beautiful way to remind us how we walk, and the path forward needs to be for the 7 generations. Cook's Jam, and all safe travels for the ones coming, and a safe meeting all week, and then safe travels to their return home. Here's Deb.
Thank you, everyone. I just want to acknowledge all of the women warriors in this room, the elders, our matriarchs, and the men that are here. We need you too. We need, even as leaders, we need the men beside us. Don't walk in front of us. Don't walk behind us. Walk beside us, because we need each other. I just wanted to say, the panel has got me all riled up. And I just feeling, this tremendous energy to, we got to do the right thing. I feel that, and I know that our ancestors are here with us today. I just wanted to say that I've been in this field for a long time, and I've been probably outspoken in a lot of ways, but it's because, like a lot of our panelists, that we really do this work from our heart. And
And we are guided, by our elders and our ancestors to be with us to do this work. It's very important work, and our children and our youth and our families are watching us. So let's just do the right thing and come together on behalf of our children and families. Shoo, click roll.
I just wanted to say thank you to the hosts, Squamish, Musqueam, and Swillitude, for allowing us to do the work on their land, and they're always so gracious, and for Kelly doing the wonderful prayer to open us.